Good morning and welcome to the 16th meeting in 2025 of the Local Government Housing and Planning Committee. I remind all members and witnesses to ensure that their devices are on silent. On today's agenda, we have at item 4 consideration of the Housing Scotland Bill at stage 2. And we have permission to continue our meeting this afternoon, and we will be suspending proceedings at around 12:30 until 2:20. We may therefore pause item 4, take item 5 and take item 5 before returning to items 4 following a suspension. The first item on our agenda today is to take evidence on the Town and Country Planning Fees for Appeals Scotland Regulations 2025 SSI 2025/124 and Town and Country Planning Fees for Local Reviews Scotland Regulation SSI 2025/126. And I welcome Ivan McKee, Minister for Public Finance, to the meeting. And the Minister is joined by Scottish Government officials, Thomas Barrett, who's the Head of Development Management, Scott Ferry, who's the Deputy Director of Chief Reporting, Planning, Environmental Appeals, Andy Kinnaird, who's the Head of Transforming Planning, and Chris Sinclair, who's the Policy Manager at the Scottish Government. And I welcome the Minister and his officials to the meeting, and I now turn to questions from members. And so thank you so much for coming in this morning. I'm going to start with an initial question, which is that we've heard from developers that the introduction of fees for planning appeals and reviews could act as a disincentive to development, including the development of much needed new homes. I'd be interested, Minister, to hear your response to that suggestion.
Well, I think it's important to recognise that the planning system costs, the appeals cost money, so somebody has to pay for that. And the principle in the Scottish Public Finance Manual is that it's the appellant that should pay rather than the taxpayer. So yeah, of course we recognise we're in housing emergency. We've also got a number of other challenges around climate emergency, biodiversity, nature, and other challenges as a consequence of that. So the planning system looks at all of that in the round. There's a well-structured process there, and if people feel the need to appeal decisions, then we think it's only right that it's the appellant rather than the taxpayer that should carry the cost of those appeals.
Okay, thank you. I'm now going to bring in Mark Griffin with a number of questions.
Thanks, Kavina. Some of the evidence that we've received, some stakeholders have told us that the introduction of fees for planning appeals and reviews favours the more well-resourced developers. I just wonder what the government's take on that in terms of denying an appeal process, particularly to SME developers. You know, we've seen a real contraction in the number of SME developers in the country, and they're really key, particularly for rural development and brownfield development. And when the government was carrying out the BRIA, what assessment you had on the impact on SME developers?
Yeah, we're very conscious of that, very conscious of the need to build more houses. In general, we're conscious of the role that SME builders can play in specific situations there. I mean, clearly the bulk of building is done by larger house builders, but we recognise the important role that SME builders can play in that. With regards to the fees for appeals, I think it's important to recognise that the cost of the appeal, in terms of the cost, not the fees, obviously if you're making one appeal, regardless of the size, there's certain things that need to be done. And then, of course, there will be some proportionality there in terms of the cost of, depending on the number of units. But by just virtue of the fact of going through an appeal, that incurs a significant amount of cost to the public purse. So we think it's only right that those costs should be carried by the appellant. In actual fact, if you look at it through that lens, then you would see that for the smaller developments, which SMEs are, by definition, those will be most likely SME builders, we would be covering less of the cost than we are in terms of what we're covering for the larger development. So if we were to implement a system that actually reflected more accurately the cost of conducting an appeal, you would find that the charges for SMEs would be significantly higher than they currently are under the proposals we're taking forward.
Okay, on that point, on cost recovery, is this system, the level of fees designed to cover full cost recovery?
Yes, now clearly you don't know how many appeals there's going to be and the complexity of those appeals, but in general that is the intent, yeah.
But was the initial consultation not explicit in that wouldn't be aiming to achieve cost?
Well, if you look across the whole planning system, we only recover about 2/3 of the fees from applicants, and that's a long-standing issue that we're seeking to address with by inflation linking fees. But I can let officials talk to the specifics on the consultation if anyone wants to talk on that point.
We did consult on the principle of saying that we weren't going to charge for full cost recovery, but I think, as the Minister has highlighted, financial circumstances have changed significantly in that period of time, and I think we were also looking at how best to ensure that the planning system is appropriately resourced in that, and ensuring that as Minister also highlighted, the Public Services Finance Manual does set out that we should be setting out initially from a position of full cost recovery as well. And it sets that we shouldn't be deviating from that unless there are very clear reasons for doing so, and also that there is a set period of time with which we will remove any subsidy from that.
I appreciate the issue relating to the Public Finance Manual and public finances in general, but do not accept the principle that if you consult on the basis that you're not seeking full cost recovery and then lay regulations, which you've just said are seeking full cost recovery, there's a disparity, and there's clearly an issue with the consultation and how the government have set out the principles of what they intend to do.
Well, I think it's important to recognise, as I said, that these costs need to be covered from somewhere. So if we're not recovering it through this process, then that would have to be covered by councils. And I think everybody around the table would agree that that there's a challenging financial situation with regards to its councils. It's also really important, and everyone involved in the planning system and in development of housing would recognise that getting more resource into the planning system is really important. So I think that this is one way to do it. And if we didn't raise this money through this route, we'd need to raise it through another route. So I think this is the most effective way to do it, where those that are seeking to take forward an appeal are charged on the basis of taking forward that appeal, and that enables us to get more money into the planning system through that route rather than through any other route.
I appreciate that's a principal point of the government. What I'm saying is, though, you consulted on a different basis to those instruments that you're introduced, and I'm asking, do you not think there's an issue between consulting with developers and the whole sector on one basis, and then introducing regulations that do something else?
Well, consulted on the basis of planning fees, and clearly there'll be people that wouldn't want us to introduce planning fees because they're going to for appeals because they'd have to pay for them. But we consulted on that basis, gathered views on that, took those into account, and then the government's brought forward proposals that we think are the right proposals, given all the factors of identifying. Because if somebody's saying we don't raise the money through that route, they'd need to be clear where else would raise the money from, either through councils having to take that from other budgets or fees for planning fees more generally having to be increased to cover that fiscal gap.
Okay, my last question, Convener, is on access to justice. The Law Society and Homes for Scotland have raised issues around the lack of any option for a refund of a fee or any fee waiver. I just wonder what consideration the government had given to any options for fee waivers or refunds, given that we know that over 50% of applications are granted on appeal.
Yeah, well, I think, there is scope for that on very specific circumstances, but more generally, if you're talking about making that conditional on the outcome of the appeal, then I think that takes you into a space which isn't conducive to what we're trying to do, because it means that the decision about the appeal has got a financial implication which could impact the decision-making process. So I think it's very important that if people want to take forward the appeal through the planning process, then, as I said, that the principle that the appellant should by and large pay for that is important, and then the planning process should run on the basis of the planning information that is in front of who's making the decision, rather than run the risk of that being influenced by any financial consideration.
Okay, thanks. No further questions.
Thank you. Megan, you indicated you want to come in.
Thank you very much, Convener. Good morning, Minister. Minister, you're on record saying that planning has not created the housing emergency, but it can help us find solutions to the challenges we are facing.
Yep.
Surely what's being proposed here goes against what you've said previously in relation to try and secure more planning developments so we can tackle the housing emergency. And is this going to squeeze out SMEs, as Mark Griffin has rightly said, given that the consultation said one thing, but you're going to do another?
No, I don't think that's the case at all. I think it's quite the opposite. What this does is it gets more resources into the planning system, which everyone recognises requires extra resource. And I said the data shows that on average local authorities only recover about 2/3 of the cost of running the planning system from fees. So I think it's important that we address that, and it's part of a range of measures we're taking, including inflation linking fees and other measures to support resource going into the planning system, which everyone will tell you is a significant part of the problem. In regard to the issue with SMEs, I already addressed that point. If you actually charged for the cost of smaller appeals in relation to how much it actually costs the system to process them, the cost of smaller appeals would be higher than it is in the proposals we're taking forward, because we recognise that there needs to be a weighting more heavily against larger developments rather than SMEs, and that is embedded in the proposals we're taking forward.
If smaller and medium developments can't progress, that's not going to help tackle the housing emergency, though. Is that something?
Well, they'll get if the appellant, same with any process. I mean, the appellant would take a view on the appeal and whether they want to proceed with that, as they do when they're taking forward an application at the beginning of the process. There are costs associated with that. So if what you're saying is that we shouldn't charge any planning fees at all, then I think that you would find resistance to that, which is a logical extension of what you're saying. If you're saying that we wouldn't charge any fees at all because it encourages more people to bring forward housing development proposals, then I think the problem with that, of course, is that it means that the planning system wouldn't be resourced to be able to process those. So you need to be able to have a well-resourced planning system, because everyone recognises that that under-resourcing is a particular challenge we need to address.
No, I understand under-resourcing, but of course that's due to years and years of underfunding of local government. But I think we need to get back to the consultation point, Minister, if we can, because I am really concerned that you've consulted for one area, but then it's as if you've ignored the responses that you've got and you've decided to take a different action. So how are you going to restore confidence, particularly within the SME sector, that you're not going to then make another decision again in the future that's going to go against consultations that you've made in this particular area?
Well, as I said, we consulted on the principle of the fees for planning appeals. We've taken on board the consultation responses. As I said earlier, of course there's going to be people that would be happy not to pay any fees for appeals. They'd be delighted to not to have to pay any planning fees at all. But that, of course, isn't the world that we live in. We recognise it's important to be able to resource the planning system. We recognise the gap that currently exists between only about 2/3 of the cost of planning. The planning system is covered by fees. We've taken a number of measures, including this measure and other measures with index linking and so on, to be able to ensure that a higher proportion of the planning system is covered by fees than it is at the moment. And we think that tackling that resourcing issue roundabout planning is an important part. One part, there are many others, of course, but it's one part of the steps we're taking to ensure the planning system is able to support taking development forward to tackle the housing emergency.
Thank you very much. Thank you very much, Convener.
Thanks very much. I'm going to bring in Alexander Stewart.
Thank you, Convener. If I can go back to the question we've touched on already, that explain why an appellant who receives planning permission on appeal should pay for the appeal, given they've already paid the planning authority the original rejected application, which may have been imposed unreasonable conditions on an award for a planning permission. So if we can just go back to that, because they've already stomped up money initially, and then they're asking again to be add more onto the process?
Well, I think it's important that we separate out the cost of running the planning system and the appeals process, which requires to be funded, separate from the decisions that are made through that planning process. So the planning process will, as I said, make decisions based on the information in front of it at various stages in that process, and that is important that that runs on that basis, and that's separate from the fees that would be charged, which I say are there to cover the cost of running the process.
And do you think that the fees will cover the running of the process at the end of the day?
Well, as I said earlier, at the moment, in total, only about 2/3 of the planning system costs are covered by planning fees. With regard to the appeals, we've sought to obviously ensure that the cost of the appeals are covered by the fees we'll be charging. But as I said, in total, the planning system costs aren't covered by fees at the moment.
Thank you, Convener.
Thanks very much. Just kind of continuing on with that, under the Verity House agreement, there's an agreement with local authorities around not ring fencing. So there has been some concerns raised that if there's a fee charged for the local reviews, that that fee won't actually go to local planning authorities. So it'd be interesting to hear what kind of discussion you've had around that, making sure that that money raised actually does what you're talking about, which is help to improve the system.
Well, there's very important principles there around about ring fencing, and I think if we were to go in here and say we're going to tell local authorities how they're going to spend their money, and I think the committee would have something to say about that. So that's an important point to recognise. We have been clear, however, that from our perspective, we would expect local authorities to spend the money that they receive through the planning system, through fees for applications or fees from appeals, and use that to support resourcing the planning system. But as I say, recognising also the fact that at the moment councils are having to put extra money into the planning system locally to be able to process the applications and the appeals that are in front of them. So I think that important principle round about no ring fencing that we've agreed through the Verity House is in place. But as I said, I would encourage local authorities to utilise that resource to support the planning system.
Okay, and then in terms of the planning appeals that come to the government, to the Scottish Government, how is that going to be managed?
Well, it's the same process. The fees that come into Scottish Government for those appeals is calculated as being sufficient to cover the costs of processing those through the system that's in place within government.
Okay, thanks for that. I'd be interested to hear also, so we have raised a number of concerns. I'd be interested to understand how the Scottish Government's going to keep this under review to make sure it's actually doing what you're setting out to do here. Do you have an idea of that annual review, that kind of thing?
Well, I mean, I'll monitor the data on number of appeals and the level of fees and the amount of resources coming in to the system on a regular basis, and would continue to do that. And clearly, if we found that there was issues there, then of course we would look at that.
Okay, and certainly we can commit to keeping under review as well. I think this also fits into a bigger picture of the challenges that we've been discussing this morning around resources for local planning authorities. And there's a bigger picture, which is, for example, not really having enough new planners coming in through the pipeline, and the lack of actual places for people to go and train in Scotland. So it's a kind of moving piece, isn't it, with lots of parts in it. So and something I noted in our papers this morning is that hopefully that this would create better applications in the first place. But something that I've been picking up, certainly in my regional work, is that there used to be a way where planners would actually meet and go on site, and that seems to be happening less. So people who are, especially SMEs, certainly in the Highlands and Islands, and maybe it's a distance issue, but there's an experience now that developers are having where they're not getting that on-site information, they're not getting really good upfront insight as to what the local planning authority is looking for in terms of height of building, roofing, materials and that kind of thing. So there's something in there as well that possibly we're losing as we have more planners retiring and younger people coming in without that transfer of knowledge. So there's there's something in the mix there that's beyond these SSIs. I understand that, but I just want to put that out and just get your thoughts on that.
No, and I wouldn't really know the specific instance locally that you're referring to, but in general, first of all, on the resourcing piece, we've taken significant steps. We've trebled the number of bursaries for planners coming through the system that government is paying for to help address the resourcing challenge. We have hired a significant number of apprentice planners into government, which again government is paying for, to support the training of more young people and not so young people coming into the system. I have done a significant number of events with young planners to support and encourage them, but also to look at routes for others with mid-career that seek to come into the planning system. So on the resourcing piece, in terms of skills, we've done quite a bit of work. And in terms of best practice, the work that Craig McLaren, the National Planning Improvement Champion, has taken forward is significant, because that's been peer-to-peer reviews across all 34 planning authorities, and the work that's come out of that has helped them to identify in a very objective way what best practice looks like, and how planning authorities can learn from each other and be able to improve the service that they offer to applicants. Because you're absolutely right, having that informed conversation early in the process is better for everybody. It helps it make the applicants the applications of a higher standard, but also allows the applicant to understand what it is the planning authority is looking for in the determination.
Thanks for that. I appreciate your reflections on that. So I don't think we've got anything further to ask in terms of questions. So I'm going to move on to the second item on our agenda, which is to consider the two negative instruments. And the first is the Town and Country Planning Fees for Appeals, Scotland Regulations 2025, SSI 2025-124. Do members have any comments on the instruments? Nobody has any comments. Is the committee agreed that we do not wish to make any recommendations in relation to the instrument? We're agreed. Thank you. The second SSI is the Town and Country Planning Fees for Local Reviews, Scotland Regulations 2025, SSI 2025-126. Do any members have comments on the instrument? No one has any comments. Is the committee agreed that we do not wish to make any recommendations in relation to the instrument? We're agreed. Thank you. We're going to move on. So I think we're going to pause. Do we need to? Well, we're going to suspend. Yeah, we're going to suspend briefly to allow a changeover of witnesses. Thank you. The third item on our agenda this morning is consideration of the Housing Scotland Bill at Stage 2, Day 5. And I welcome to the meeting the Cabinet Secretary for Social Justice and her officials. And we are also joined both online and in the room by other members of the Scottish Parliament who have lodged amendments to the bill and are present to debate those with us today. Members wishing to speak should indicate that by catching my or the clerk's attention. Voting is by a show of hands, and it's important that members keep their hands raised clearly until the clerk has recorded their names. And this is especially important for colleagues online, and I'll let you know when we have counted your vote. We will not dispose of any amendments beyond the end of Part 4 of the bill before 1 o'clock today. At previous meetings, we explained the procedure, and we will be following, and I propose to move straight into the consideration of amendments. I remind members that we have additional meetings this week to finalise our consideration of the bill at Stage 2. The length of our speeches and our interventions all contribute to time taken to consider the amendments. And I ask members to take an opportunity for brevity while recognising it's important we thoroughly scrutinise the legislation. And we'll now begin. We're going to begin with a grouping called Dealing with Evictions. And I call Amendment 119 in the name of Megan Gallagher, grouped with amendments as shown in the groupings. Megan Gallagher to move Amendment 119 and speak to all amendments in the group.
Thank you very much, Convener. And I feel that I might fall at the first hurdle in terms of brevity, just due to the number of amendments that I have in this grouping. But if I may firstly thank the wonderful team at Marie Curie who have worked alongside MSP colleagues to table the amendments that I've submitted in this grouping. A study undertaken by Marie Curie and the University of Glasgow titled Dying in the Margins, the Cost of Dying, laid bare the barriers to and experiences of dying at home for terminally ill people, their families and carers living with financial hardship and deprivation. Research analysis outlined the lack of compassion by immediately evicting relatives after a terminal illness or a terminally ill person has died, with relatives forced to vacate properties only 2 weeks after the death, with no alternative accommodation in place. Not only are these individuals dealing with the tragic loss of a loved one, having to box up their possessions whilst grieving, but they are also faced with the challenge of finding a new property should they receive an eviction notice, especially if they have no succession rights. I think we can all understand and sympathise with those individuals impacted because grief takes longer than 2 weeks, and with the additional stress of whether someone will live have a home that they can live in. This can take an unbearable toll on families who are adapting to life without caring for someone 24/7. And I seek to bring some compassion into the housing bill by submitting these amendments. Marie Curie is rightfully advocating that the housing bill is used to strengthen the rights of terminally ill tenants and their families to ensure that they're protected from eviction. And oral evidence sessions undertaken by the UKCB to better understand people's experiences of bereavement, the Commission found serious issues with housing eviction. It was noted how people in local authority housing can be asked to move out if they are not on the tenancy agreement and may be required to move to a smaller property. Surviving family members then face further challenges in raising sufficient funds to cover security deposits and advance rent payments on a new property at a time when they've also likely had to pay expensive funeral or other administrative costs associated with death. A survey conducted by Opium for Marie Curie concluded that 27,600 people in Scotland every year must move out as a result of a close bereavement. 13,200 have had to move out because they could no longer afford to live there. 11,400 had to move because they did not hold the tenancy. Under 35s are likely to be impacted by this. As a result of a bereavement, that's 28%, followed by 35 to 74s, 11%, 55 to 74s and 75 plus, both 5%. People find themselves in precarious situations in these respects, declaring themselves as homeless, for example, as the right support is not in place to help them. Following discussions with the Cabinet Secretary, it is not my intention to press amendments 119 and 120 today on the premise that there is a further discussion with stakeholders and supportive MSPs on protections from evictions for terminally ill people. I would like to work with her to define terminal illness, as it is understandable that the prognosis can be wide in terms of defining individuals and conditions to ensure there are clear margins between chronic, life-limiting and life-ending diagnosis. I will wait to see what the Cabinet Secretary says before I consider the other amendments related to terminal illness, particularly in relation to succession rights for bereaved families, because I do believe that this is really important, and I also think it will help tackle issues relating to unintended homelessness on the back of a terminal illness. Convener, if you can bear with me, I would like to turn to 487, which is another amendment relating to a different matter, before I conclude my remarks just now. And this amendment relates to a similar amendment submitted by Willie Rennie, 452, and it relates to decisions that were taken during the time of COVID, legislative changes to protect tenants from eviction, but that has made it significantly more difficult for a congregation to be able to reclaim the use of a manse once they have called a minister. Parishes and vacancies in between ministers often let out the manse, helping to provide that much needed income, as well as making that dwelling available for use. Recovering possession on manses which have been let out on short-term basis, and I do believe this will be exacerbated should Section 24 of the bill be enacted in its current form. For the bill to be proportionate, there needs to be further discussions with the Church of Scotland and other religious groups to ensure that the bill is fair and encompasses all groupings. Section 24 of the bill inserts a new Section 51A to the 2016 Act, which provides that the first-tier tribunal must, when specifying in an eviction order the day when a tenancy is to end, consider if it would be reasonable to delay the ending of the tenancy. In doing so, the tribunal may consider certain factors, in particular these factors relating to the tenant and factors relating to the landlord. Those relating to the landlord are whether a period of delay in bringing the tenancy to an end would cause the landlord to experience financial hardship, have a detrimental impact on the health of the landlord, or have another detrimental effect on the landlord due to the landlord having a disability. The balancing protections available to landlords under this section will not be available to a landlord who is not considered a natural person, and that's the point that I'm wishing to make through my amendment this morning. This will not be available to Church of Scotland congregations. Manses are owned or let either by local congregational trustees or on behalf of the congregation or by the Church of Scotland General Trustees. Factors and evidently cannot apply to the landlord in such cases. Factor is unlikely to apply regardless of whether the landlord is a general trustee or local congregational trustees, as their interest in securing vacant possession of a manse is not primarily financial. It is to use the manse for a housing of a minister. Prior to the removal of the mandatory eviction ground that let property was required for occupation by a person engaged in the work of a religious denomination as a residence from which their duties were performed, the Church of Scotland let out a large number of their manses on a temporary basis as a result of the parish minister retirements and recruitment difficulties. The income generated from such lets is an important contribution towards the sustaining the work and the mission of congregations in their local communities. And when ministers are called to a parish, it is important that a manse is available for them, but it's challenging for a congregation to let an empty manse when it may not be able to get the house back when it's needed. This is already resulting in many situations where congregations are now unwilling to let out such properties, and the Church finds itself in an uncomfortable position of being the custodian of a considerable number of large dwellings standing empty, and I don't think this helps tackle the housing emergency that we're currently experiencing. What I'm asking for the Cabinet Secretary to do this morning is to consider the impacts of various manses, the Church of Scotland, but other religious groups as well, as highlighted in the amendment submitted by Willie Rennie, to see if there is a way forward in which it does not become difficult for these properties to be let out, but also brought back into usage under the Church when a minister is made available. I understand that there is, of course, an amalgamation process underway, but we do need to be looking at all of these various different issues as part of the housing bill when it relates to tenants' rights. Convener, I'm going to end my remarks there. I know I will be coming back shortly to speak to Edward Mountain's amendments. Thank you.
Thanks, Megan. I'm actually going to ask you to move Amendment 119, and actually also, if you would like to speak to Amendments 163 on behalf of Edward Mountain now, you can do so.
I don't plan to move 119, Convener, but if I may look towards Edward Mountain's amendments.
I'm just going to pause you there. So part of the process is you have to move it and then we will withdraw it. So you have to move it and then we'll come back to you after the whole debate and we'll do a wee process to withdraw it.
Thank you, Convener. Yeah. I will move to later withdraw.
Thank you.
Thank you. In terms of Amendment 163, under Edward Mountain, this amendment is to ensure that the 3-month eviction process is concluded within 3 months of a tribunal application being submitted by the landlord. I do believe that Edward's intentions in relation to these amendments is to ensure that the tribunal application process is dealt with swiftly, to make sure that instead of the current process, that we do have a defined 3-month eviction process which will be concluded within that period of time, which will allow not just the tenant to be able to move on to another property wherever that may be, but in terms of the landlord also being able to look towards perhaps bringing in a new tenant therein. That relates to 163, 164, 165 and 166 and also 167. So I do believe I can conclude my comments there on those ones, Convener, because I think it's quite straightforward what Edward Mountain's intending to do. Thank you.
Thank you very much. And now call Fulton McGregor, who's joining us online to speak to Amendment 491 and other amendments in the group.
Thank you, Convener, and I'll take the opportunity here to mainly speak to my own amendment 490. I want to say at the start that this amendment has come about through a discussion with the Church of Scotland, and I know that Willie Rennie's amendment 452 came around through similar conversations and maybe in a similar area, and Megan Gallagher has just highlighted some of that. I also want to thank the Cabinet Secretary for the constructive conversations, and I can confirm at the outset that I don't intend to push, and the amendment is more a probing one. So this amendment seeks to address the issue for a landlord who is not an individual in relation to the proposed new Section 51A to the 2016 Act. The bill, as drafted, provides that in considering a period of further delay, the tribunal may consider in particular if a period of delay in bringing the tenancy to an end would 1. Cause the landlord to experience financial hardship, 2. Have a detrimental effect on the health of the landlord, or 3. Have another detrimental effect on the landlord due to the landlord having a disability. These provisions mirror the considerations for a tenant in Section 51A 2A. In the case of a manslate, the landlord may not be able to prove financial hardship as he will still be entitled to rent during the period. Provisions B and C couldn't apply to a landlord who wasn't an individual. The proposed new clause would enable the tribunal to consider another detrimental effect on a landlord who is not an individual. And for example, in the case of Manses, the detrimental effect would be that the house couldn't be used by the landlord for occupation by a person engaged in the work of a religious denomination as a residence from which the duties of such a person are to be performed. The detriment would prevent a minister being called to the charge or being able to take up occupation in the parish if the manse is occupied. And the example that was given to me, Convener, when I met with Church of Scotland representatives, was one where a manse, for example, is used for charitable aims such as hosting refugees. And so this amendment may be helpful in such a scenario. Convener, as I said at the start, in closing, I'll just reiterate that I don't intend to push this amendment today, and I'm happy to continue discussions with the Cabinet Secretary and others ahead of stage 3. Thanks.
Thank you. I call Willie Rennie to speak to Amendment 452 and other amendments in the group.
So Megan Gallagher and Fulton McGregor have set out the case very well for the problem that churches, religious groups are not natural persons, they are groups of people, and so therefore the bulk of the criteria that I've set out don't apply to them. And my amendment seeks to include all religious groups rather than just the Church of Scotland, which is what Megan Gallagher is proposing, and actually Fulton McGregor's proposal for including an additional criteria, I think, is a sensible way to solve this problem as well. The main problem here is we've got manses that are potentially not getting used, and some in fact are not getting used because congregations and other religious groups fear that they won't be able to get those properties back when they need them, and we need to try and solve that problem. Now, I know the Minister isn't going to accept my amendment. I don't know what she's going to do on the other amendments, but I'd like to hear from the Cabinet Secretary what she intends to do about this problem, because it's a real thing, whether she thinks Section 24 exacerbates the problem or not. Certainly Church of Scotland congregations are fearful about letting out the manses on a short-term basis because they fear they won't be able to get them back when they need them. So I'd like to understand what the Cabinet Secretary and the Government is going to do to try and improve communication, improve information, or the application of it. Yes.
I thank Willie Rennie for giving way. I think there's also issues in relation to the tribunal, because usually the congregation needs to go to the tribunal. They've got to weigh up the costs associated with that, the time, of course, that's going to be impacted in terms of being able to move a minister in and move the tenant out. And that's, of course, if the tribunal agrees with that decision as well. So do you believe that there's an issue surrounding the tribunal, and we need to look at that in relation to these groupings that are impacted?
I mean, that might be one of the solutions to this. I mean, that's partly what our amendments are trying to achieve, is to remove the ability to delay, because that exacerbates the problem. But I don't know whether that's what the Minister's thinking in terms of a solution to this problem. But I will conclude at that point because I'm keen to hear what the Minister's got to say.
Thank you. Maggie Chapman to speak to Amendment 187 and other amendments in the group.
Good morning. Thank you, Convener. And I, like Megan Gallagher, will fall foul of the request to be brief, in this group at least. But then one of my amendments is 12 pages long. So I think I can get away with it once, maybe. A warm, safe home that we call our own is absolutely central to our well-being. That being the case, forcing somebody out of their home should only be done in the most rare and unavoidable circumstances. At the moment, eviction notice periods work differently depending on how long you've been in the property, and I struggle to see the justification in that. Being forced from your home against your will is going to have an impact regardless of how long you've been there. That being the case, my Amendment 187 provides a 4-month notice period for everyone, so all tenants are treated equally. It also has the virtue of simplifying the system. The same amendment provides a 12-month protection for eviction in the same way as the Renters' Rights Bill is shortly to give tenants in England. This would ensure both that people have a guarantee of a minimum 1 year of stability in their home, and also ensures protections in Scotland don't fall behind those of other parts of the UK. My amendments 188 and 200 provide a ban on winter evictions, specifically between November and March. Disallowing evictions within the winter period is not at all exceptional or experimental. We've had an evictions ban before in Scotland very recently, and almost the same measures as I'm proposing have been in force in France for over 70 years. Similar provisions exist in US states, where evictions cannot happen when the temperature drops below a certain level. In a country that can be as cold as ours, I don't think I need to press home the point too strongly that we should not be moving people out of their homes and into often poorly insulated temporary accommodation, and where new arrangements don't work out, onto our freezing streets. There are, of course, appropriate exemptions, but the ban will apply for most of the common eviction grounds. I understand the Scottish Government's approach prizes flexibility, And this is appropriate when ensuring evictions don't coincide with exams taken by a member of the household, for example, which can happen at any time of the year. The case is similar for religious holidays, with as clearly Christian and Muslim households, for example, will need protection against evictions at different times of the year. But it's different for winter evictions. As we all know from sliding down the Royal Mile in the ice and snow, Scotland is reliably cold in the last few months and first few months of each year. The Scottish Government's approach is simply asking for inconsistency. The bill says that tribunals may consider delaying an eviction due to a seasonal factor, but they may not. And they may also differ in the interpretation of what a seasonal factor is. Even if you have concerns about particular aspects of the drafting, I would ask members of the committee who agree with the basic principle here to support the amendment when I press it, which I intend to do. I'll be happy to work with them ahead of stage 3 to iron out any details. If the Cabinet Secretary is not intending to support this proposal, I have one simple question. The Scottish Government, including both my party and that of the Cabinet Secretary, brought in an evictions pause through the Cost of Living Act. So if it was the right thing to do then, why is it not the right thing to do now? Moving to Amendment 251, this gives effect to a long-standing ask from Generation Rent. It would require the first-tier tribunal, when allowing an eviction, to either order a payment to the tenant of equal to 2 months of rent, or allow the tenant to withhold the last 2 months of rent. This is in recognition of the significant costs tenants incur when being evicted. Polling for this by Survation for Generation Rent shows how much money tenants lose. 52% of tenants reported that they took more than 4 days to pack, move and clean at the end of a tenancy, often requiring time off work, which can be costly for those who do not have the leave available. Due to overlapping tenancies, 40% of private renters reported they paid rent on more than one property at once when moving home, and over a third, 40%, of these renters paid rent on 2 properties for more than 2 weeks. And all of this is not to mention the costs of cleaning or having the property cleaned and hiring vehicles to move possessions. When upfront costs, deposits set at 5 weeks' rent, and time off work are all considered, it typically costs renters £1,400 just to move home. This is a modest measure in this amendment to help people deal with those costs, often being put on them at short notice. Moving to other amendments in the group, there are many in the group that we in the Greens support. Mark Griffin's statutory review of eviction grounds is a timely and helpful measure. A root and branch review is desperately needed. His amendment to restrict evictions where ECO4 energy improvements have been made addresses issues arising from a number of troubling evictions we have seen recently, whereby people have agreed to the disturbance of installation works only then to be evicted, so the more energy efficient property can be sold or rented more profitably. Megan Gallagher's amendments to restrict evictions in the case of terminal illness make well overdue compassionate changes. I also welcome the tougher sanctions on landlords who don't play by the eviction rules or seek to manipulate them. These have been brought in by Katie Clark, and I thank her for doing so. However, there are a number that I cannot support. Edward Mountain's amendments appear to water down the bill's plans for evictions to be delayed. I opened by noting that evictions should happen only in the most rare circumstances and only when absolutely unavoidable. That being the case, and with all due respect to faith groups who rent out properties, needing the property for a religious purpose is not a good enough reason for an eviction not to be delayed. I also see no reason to exempt the Church of Scotland alone from these provisions. I therefore would encourage colleagues to vote against Willie Rennie's 452 and Megan Gallagher's 487. Thank you, Convener.
Thank you. And I call Emma Roddick to speak to Amendment 250 and other amendments in the group.
Thank you, Convener. Amendment 250 modifies the 2016 Act to give local authorities and registered social landlords first refusal on purchasing the property when a landlord evicts a tenant for the reason of intent to sell. Amendment 141 adds using intent to sell as a reason for eviction and then not selling the property to the list of wrongful eviction reasons. This is triggered if the property is not sold within a year. We do know full well that the reason is misused. There may be legitimate reasons that a sale is held up or that a council or social landlord doesn't want to buy the property, but landlords being able to use intention to sell with no checks or balances on whether that claim is being made in good faith, as it stands, is too easy when we're trying to crack down on unfair evictions. I also have a lot of sympathy for Maggie Chapman's amendments in this group on winter evictions and notice periods. We do have to remember that evictions can be a matter of life and death, and they can certainly very quickly become life-changing. I don't think that the current law or the bill as introduced recognises that enough. We do recognise the landlord's right to sell up or move into their property or let a family member move in, but if eviction might risk the life of a tenant, as well as their right to a safe and secure home, then the balance of rights must come down on protecting that tenant. Thank you.
Thank you. Now, call the Cabinet Secretary to speak to Amendment 362 and all other amendments in the group.
Thank you, Convener, and good morning. And I also, with apologies, will not be brief given the amount of amendments from different members in this, but I can assure you, Convener, this will be the largest speaking note, I promise. I do share the intention behind many of the amendments in this group to increase eviction protections in certain circumstances and to strengthen existing penalties where an unlawful eviction or wrongful termination occurs. However, I cannot support them for the reasons I'll set out. Amendments 119 and 120 in the name of Megan Gallagher would prevent private landlords applying to the tribunal to evict where a tenant or a member of their household has a terminal illness. I am very sympathetic to the outcomes that these amendments are seeking to achieve. However, they do not strike the right balance between the protection for tenants and the rights of landlords. The amendments would prevent a landlord recovering a property regardless of the circumstances and for an indeterminate period, including where those circumstances relate to their own health or ability to continue as a landlord. We have strong existing protections from unfair eviction, and the Tribunal must consider all circumstances in determining whether it would be reasonable to grant an eviction, and this would include where a person has a terminal illness. Section 24 to 27 of the Bill further strengthens these protections, ensuring that where an eviction is granted, the Tribunal must consider whether there should be a delay to the enforcement of that eviction. This increases protection for all tenants, including those with terminal illness, and ensures that the rights of tenants and landlords can be appropriately balanced. However, I very much appreciate where Megan Gallagher is coming from. She spoke earlier, Convener, about bringing compassion to this bill, and I can assure her that I share that determination and thank her for the genuinely useful and very meaningful conversations that she and I have had over the past few weeks in particular, and also the discussions I've had directly with Marie Curie. I do absolutely accept the point that Megan Gallagher has made, that ending of a tenancy via an eviction is an exceptionally difficult time and that people should be treated sympathetically and provided with support and advice. And this will particularly be the case for those with a terminal illness. I am therefore very keen to develop guidance for private landlords, setting out good practice in this area, seeking input from organisations such as Marie Curie that support those facing terminal illness, to ensure tenants are supported as early as possible to avoid the ending of a tenancy and eviction where possible. And I hope that Megan Gallagher will be able to contribute to those conversations and meetings as well. She also mentioned amendments on succession, which I believe are in a later group. And without spoiling the surprise of the speaking notes for Group 22, Presiding Officer, I'm also very keen to work with Megan Gallagher on many of the aspects that are in that group too. Amendments 122 to 129 in the name of Megan Gallagher would add terminal illness as a specific consideration for the court or tribunal when exercising these new duties to consider a delay to the enforcement of an eviction. While the bill will allow the court and tribunal to take terminal illness into account, I do understand the desire to highlight this specific issue. Further consideration is needed on how best to address this in legislation, but I am happy to work with Megan Gallagher to bring forward amendments at stage 3 to ensure that terminal illness is added to that list. On that basis, Convener, I would ask Megan Gallagher not to press these amendments and work with me ahead of stage 3 on that issue. Amendment 491, in the name of Fulton McGregor, would amend the new duty to consider a delay to the enforcement of an eviction to include the detrimental impact on a landlord who is a company or business as a consideration. I can confirm that while the bill specifically refers to a number of factors, it is a non-exhaustive list and the Tribunal may take all circumstances into account. The impact on the landlord, regardless of whether they are an individual or business or other, will be a factor in determining whether it is reasonable to delay, and this amendment is therefore not necessary, and I would ask Fulton McGregor not to press. Amendments 163, 164, 165, 166 and 167 in the name of Edward Mountain would prevent the Tribunal and courts from ordering a delay to an eviction of longer than 3 months. I understand these amendments will be responding to concerns from landlords about the length of any delay. However, I do not think it's appropriate to restrict the discretion of the Tribunal and courts. Also, there are issues with the drafting of the amendment that mean in practice there could be no delay or a minimum delay, undermining the purpose of the measures in the bill, and I would ask Edward Mountain not to press. Amendments 452 and 487 in the name of Willie Rennie and Megan Gallagher would create further exceptions to the duty to consider delay where the property is needed for religious purposes and where the landlord is the Church of Scotland. I recognise the concerns that have prompted these amendments, however I am not persuaded that an exemption is appropriate. Existing exemptions to the duty reflect areas where it would rarely be reasonable to delay enforcement, mainly related to the conduct of the tenant. For all other repossession grounds, the Tribunal is the correct place to balance the rights of tenants and landlords. The type of landlord or purpose for which the property will be used in and of itself does not seem to merit an exemption, particularly where it removes the protection these measures are intended to provide for tenants. The requirement on the Tribunal to take all the circumstances into account, including those of the landlord, will ensure that a delay to an enforcement order is only ordered where it is reasonable to do so. This protects landlords' interests as well as tenants, and I would therefore ask Willie Rennie and Megan Gallagher not to press. But yes.
Thank you, Convener. I should refer members to my register of interest as a member of the Church of Scotland. My understanding is that the Church of Scotland was keen to have this issue debated because it has a number of properties that it would like to make available due to long-term vacancies in ministry, but obviously that it would still require those properties when ministry vacancies are filled, and that it's found it challenging to engage with the Scottish Government on this. Would the Cabinet Secretary be amenable to having a discussion with the Church of Scotland about how its quite considerable property portfolio can be used to help tackle the housing crisis with the limitations on that portfolio?
I would indeed. My very next paragraph was to say that the aspects that Willie Rennie, Megan Gallagher and now Ross Greer have mentioned do reiterate a concern from the Church of Scotland, and I do appreciate their desire to have their housing stock also to be able to be made available to assist with the housing emergency where possible. I'm very keen, therefore, to have those discussions with the Church of Scotland to ensure that we can go through the concerns that they have and work through those concerns. And I hope through that to be able to provide the reassurance that I think we all want to see and that I believe is the intent behind the amendments today. So happy to have those discussions between my officials and indeed myself. It would be useful as well with the Church of Scotland. Amendment 187 in the name of Maggie Chapman inserts a new section into the 2016 Act that would extend notice periods for ending a tenancy, for example when there is rent arrears, to 4 months rather than the current 28 days, or 12 months from 84 days where the landlord is ending the tenancy to sell or the property is to be sold by the lender. This change would make it harder for a landlord who needed to sell a property due to financial hardship, delaying the process for a substantial period of time contributing to this hardship. It would also mean that a landlord could not end a tenancy quickly where there was antisocial behaviour or the property had been abandoned. Scottish ministers are committed to a wider review of repossession grounds, however, and I think this issue is best considered as part of that work. Again, I can appreciate what Maggie Chapman is looking to do with these amendments, but I am concerned of unintended consequences.
Thanks, Cabinet Secretary. I just wonder how you respond to the question then of there being different protections in other parts of the UK where there is that 12-month, or there very soon will be that 12-month protection?
Well, I've
with appropriate exemptions for the issues that you raise, like abandonment of property or antisocial behaviour.
Well, I've looked very carefully only yesterday at what is proposed in the UK bill, and there are areas where, again, the aspects up in Scotland provide better support for tenants, and there are, of course, different aspects of the overall application of a tenancy, which mean that we can't just look to replicate what's happening in a UK bill. I am happy to carry on conversations between stages 2 and 3 should there be a situation where a tenant's rights would be less in Scotland than there are in other parts of the UK. That's not how I look at legislation, but I'm more than happy to be challenged if we feel our rights are falling short of elsewhere. But I'm also content that there are still other areas where the rights of a tenant in Scotland are better served, and indeed also sometimes the rights of the landlords are better served by the current circumstances. But if there are aspects where we are falling short, then I'm quite happy to go through those aspects in detail in the run-up to stage 3. Amendments 188 and 200, also in the name of Maggie Chapman, would introduce a winter eviction enforcement ban, except in limited circumstances, similar to the temporary emergency measures under the Cost of Living Act. The time-limited nature of the Cost of Living Act was a key factor in achieving the lawful balance between the protection of tenants and the rights of landlords. However, Maggie Chapman's amendment is permanent and would apply every year, and this is in addition to the enhanced eviction protections already in the bill. Now, I too want to ensure that we protect tenants to prevent, as far as possible, the negative impacts of eviction, but we must do so in a proportionate manner. In developing the bill, we explored greater restrictions on evictions over winter and consulted on this as part of our New Deal for tenants. This highlighted support for additional protections, but reflected that the Scottish climate can be challenging at any time of year, and that other times also present financial and emotional well-being pressures for people, such as periods of religious significance and exam periods. I'm also concerned about the creation of an eviction season after the ending of the winter period and the negative impact of this additional pressure on housing and homelessness services, as well as tenants finding alternative accommodation. The measures in the bill ensure a more person-centred approach, with the tribunal or court needing to consider whether there should be a delay to the enforcement of an eviction at any time of year, although seasonal impact is set out as a specific factor to be considered. Now, I understand the attention behind Amendment 250 in the name of Emma Roddick is to increase the supply of affordable housing, which is something that we are all committed to. However, this amendment does not appropriately take account of landlords' rights, and it would be overly restrictive, preventing landlords selling a property on the open market, even where they had good reason for doing so. Should landlords decide to exit the market due to the increased risk of being unable to dispose of their property on the open market, this could lead to negative unintended consequences, and I therefore cannot support it, but I would like to reassure Emma Roddick that in addition to selling empty homes, private landlords can already approach social landlords to sell their property with tenants in situ. On our affordable housing supply programme supports this, where there is a clear strategic purpose and the tenants are at risk of homelessness. A recent example includes the purchase of 20 homes in March this year, most of which were tenanted in a pressured area of Perth and Kinross, and we will continue to promote this existing flexibility through our close working relationships with councils and in the process of strengthening our guidance to encourage this still further. I would ask Emma Roddick not to press this amendment, but will keep her informed and would welcome her thoughts on that strengthening of guidance that we will be undertaking. Amendment 251, in the name of Maggie Chapman, sets out a proposal which responds to concerns about both the costs of moving where a tenancy ends through no fault of the tenant and the misuse of repossession grounds. I am sympathetic to the issues raised, however, further detailed consideration of the need for and an impact of this assessment is required. This would be best done through the review of repossession grounds we are committed to. Amendments 362 to 368 and 395 in Paul McClelland's name would ensure that tenants who pay no rent or a low rent are appropriately compensated under the new unlawful eviction damages process. Current unlawful evictions legislation applies to all residential occupiers. This means that the provisions apply to all forms of tenancy and to forms of tenure other than a lease, such as a service occupancy or licence. It is therefore possible that a person occupying a property does not necessarily pay rent or pays a low rent. Changes in the bill that base damages on a multiplication of monthly rent could disadvantage people in these circumstances, and that's not our intent. These amendments address this issue by prescribing a figure of £840 to be used for the calculation where no rent or low rent is paid. £840 is based on the average rent of a two-bed privately rented property, the most common size in the PRS. There are also powers for ministers to amend this amount through regulations. Amendments 369 and 404 in Paul McClelland's name change the compensation that can be awarded where a wrongful termination occurs to a multiplication of monthly rent between 3 to 36 times the monthly rent, mirroring the calculation of damages for an unlawful eviction. This amendment also ensures that, as set out above, tenants that pay a low rent are appropriately compensated by prescribing £840 as the figure to be used for the calculation. There are also powers for Scottish ministers to amend through regulations. Amendments 268 in the name of Mark Griffin introduce a requirement for Scottish ministers to carry out a review of eviction grounds under the 2016 Act within 12 months of royal assent. As I've said, I remain committed to this review for the private rented sector, and I understand Mr Griffin's desire to see it carried out in a timely manner. To deliver a detailed and robust review of repossession grounds, work must be supported by stakeholder engagement, and 12 months' time frame is at risk of limiting the scope of the review. I think Mark Griffin would agree this is not what any of us would wish to see. I wrote to members following committee on the 6th of May and committed to engage with committee members on a range of issues, and as part of this I will write to committee members following the conclusion of stage 2 with more information regarding our plans. But I therefore ask Mark Griffin not to press this amendment. Amendment 269, also in the name of Mark Griffin, introduces a similar requirement for a review of all the other grounds for eviction within the same timescale. There is no existing commitment to review the grounds for eviction more broadly, and no evidence of a need for a review for the social rented sector, or indeed any calls from stakeholders to do so. Also, as no new tenancies can be created in relation to older protected or assured tenancies, this broader review would have little benefit, and I would therefore ask Mark Griffin not to press. Amendment 141 in the name of Emma Roddick seeks to address an important issue, the misuse of repossession grounds, which was also highlighted by this committee's Stage 1 report. No landlord should wilfully mislead a tenant or the tribunal into ending a tenancy. There are existing penalties for doing so through the Scottish Tribunal's offences in relation to Proceedings Regulations 2016, which could result in imprisonment for up to 2 years, a fine or both. I recognise the need for further action in this area. However, I am not convinced that this amendment will deliver the outcome being sought. It is through the wider review of repossession grounds that this issue is best considered. But I would reassure members we are taking immediate action to increase penalties for wrongful termination through Amendments 369 and 404. This would see compensation for a wrongful termination increasing from the current maximum of 6 months' rent to 36 months. I therefore ask Emma Roddick not to press. Turning to Amendments 409, 413... Yes.
Thank you. I think there's some really interesting amendments in this group, but if I can focus on Amendment 141 in the name of Emma Roddick, who raises the issue of where a landlord says, I intend to sell, therefore you need to go. I just wonder if the Cabinet Secretary would accept that if that happens, and it does happen quite regularly, that there is actually no monitoring of whether the landlord does put the property up for sale or not, or indeed sells it. So it's not, it just isn't happening, and I think that's what Emma Roddick, she's nodding, that is the issue that she's trying to address. So it does need to be addressed.
Well, I would agree, and the conversations that I've had directly with Emma Roddick on this one absolutely have further strengthened my opinion that there can be, and indeed in some circumstances has been, a misuse of this ground. That's why the existing penalties are very strong. But I do still exist, regardless of those current existing penalties being very strong, that this can happen. And one of the aspects around that may be the lack of monitoring, which is why I'm very keen that it's looked at in the review of repossessions, because we do need to, again, as we've done for other aspects of this bill, not just rely on something being in the current legislation if it's not being used to the benefit of the tenant, or indeed in some circumstances to the benefit of the landlord. So we do need to look at why those aspects are still happening. Monitoring, I'm sure, is one of these areas that will come up in the review of repossession grounds.
Intervention.
Yeah.
Thank you. So monitoring is key. The question is, who does the monitoring? And then who does the enforcement? Because the reality is, at the moment, if you're a tenant and you're told by the landlord, I intend to sell, therefore you need to go, chances are the tenant will just go and will not bother monitoring what is happening with that property. And then, of course, they fall foul of the issue that Maggie Chapman's raised at 251 with the cost of removal. Very good point, because the cost of removal can be extremely high. I say all this because I've been in that position myself here in Edinburgh. I've been told, and actually the property did sell. I did check it. It did sell, but I incurred significant costs to move. But if the property hadn't sold, if I wasn't monitoring it, then it could just have been rented out again. So I think these are significant issues that are being raised. The question is, who does the monitoring?
And indeed that will be a question I'm sure we'll come to during the review of repossession grounds when we get into the details of those aspects, because we can't sort that out in terms of the details of this within the bill. But that clearly is something that we will have to go into, because again I go to the point there's no point having those aspects within legislation if we are not able to use them, whether that be because of monitoring or other areas where there are gaps in the implementation of the property. So we need to look at the actual use of the legislation, and awareness of rights is obviously one of those very key aspects to that. But the monitoring is indeed challenging.
On that, I wonder if the work that the Cabinet Secretary is considering around data collection in another part of the bill might help to highlight that kind of inconsistency. If we are getting the kind of data that I've suggested from landlords, then it would be much easier to spot when intent to sell is being used and then the property is being let out at a different rent further down the line.
Well, the aspects that we're looking at around data collection within the bill are to ensure that we can implement rent controls, and I appreciate there are other areas of data that members may wish to see collected for overall information to do with the private rented sector, and I think that's one of the areas where in one of our, I think, many roundtables we'll be having over the summer, convener, we will have to look at that challenge of why are we collecting the data, what is its purpose, what will it be used for. But those are the types of questions that we will need to get into if we're looking even just specifically at this issue around evictions and whether a property has been sold or not, is around how often that is used and how we can monitor the actual selling of properties as well. But those are details that will have to be teased out. Whether that can be done in the data collection, as I say, because it is specifically there to do with rent control implementation, I don't know, but it is a challenge we will have to come back to.
Will the Cabinet take Another quick one, and I thank Graham Simpson for coming back to Amendment 251. You mentioned the review of repossessions, repossession grounds. Well, I wonder, in the letter that you mentioned, you would write to the committee after this, after stage 2, could you include the time frame for that review, so we know when we would have that information and what we will be able to do with it when it comes out?
So the reason for me mentioning the letter that I'm intending to send to committees, I'm very conscious I'm sitting in front of committee offering to work on quite a great deal over the summer with committee members, conscious of their commitments over the summer, particularly within constituencies, and also our time limit that we can achieve before the election. So I'm very keen, that's exactly why I want to send that letter, to be able to set out what the government's suggested workload is, to seek committees' views on that. So there is a full openness of what we expect to be able to do in what areas. So my hesitancy about particular giving timeframes for each particular one is I'm actually notching up quite a lot of those commitments. So I just want to make sure that in the round, in a totality, once I look at it, that those are genuinely deliverable. Okay. So I don't overpromise.
That's fine.
Or indeed ruin everybody's summer holidays to too great an extent. If I may, Convener, I assure you I'm nearly there. Turning to Amendments 409, 413 and 414 in the name of Katie Clark. Amendment 409 would introduce a new offence with the potential for a prison sentence for landlords who are found to have misled the tribunal or tenant into ending a tenancy. I understand and sympathise with the hardship that wrongful termination can cause, as we have mentioned, and agree it's vital, suitable recourse and proportionate compensation is available. But I don't think the amendment is necessary, as I've already set out in relation to 141. Amendment 413 seeks to increase the maximum penalty that can be applied for wrongful termination from 6 months to 36 months. I'm supportive of deterring landlord malpractice, and as I've set out, Amendment 369 seeks to do this. I sympathise with the intent of Amendment 414, however I cannot support it. As I've already said in relation to other amendments in the group, there are existing offences that can be used in relation to the provision of false information to tribunal proceedings, and we are strengthening penalties through the bill in relation to wrongful termination, and I would therefore urge Katie Clark not to press. Mark Griffin's Amendment 502 would prevent an eviction where a landlord has received ECO4 funding for energy efficiency measures in the previous 12 months. I recognise the good intent behind this amendment, however I cannot support it. The amendment does not enable the circumstances of a landlord to be taken into account, and it therefore does not strike a proportionate balance between the rights of tenants and landlords. There are existing protections through the current legal framework that ensure that all circumstances of a case are taken into account when deciding whether it is reasonable to grant an eviction. I share Mark Griffin's concern around the issue of potentially vulnerable tenants being evicted after such funding has been received. However, the design of the ECO4 scheme is decided by UK ministers, and they did not agree to changes we proposed last year to strengthen safeguards for householders. I would welcome his support in pressing them to urgently do so, but would urge Mark Griffin not to press this amendment. In summary, for the reasons I've set out, I would ask members to support the amendments in the name of Paul McClellan, and would otherwise urge Megan Gallagher, Fulton McGregor, Edward Mountain, Willie Rennie, Maggie Chapman, Emma Roddick, Mark Griffin and Katie Clark not to press their amendments, and if any of their amendments are pressed, I would urge the committee not to support them. Thank you, Convener.
Very much, and I now call Mark Griffin to speak to Amendment 268. And Mark, while you are speaking to that, you could also speak to Katie Clark's Amendment 409 and any other amendments in the group.
Thank you, Convener. In speaking to Amendment 268 and 269, these require Scottish ministers to review the grounds for eviction in Schedule 3 of the PRT and other types of tenancies Scotland Act 2016 within 12 months of the bill coming into force. Now, it's clear from analysing the caseload of the First Tier Tribunal, listening to the submissions of organisations acting on behalf of tenants, and observing the outcomes of changes made to Schedule 3 of the Private Rented Tenancies Act and the emergency pandemic legislation, that at least some of the grounds for eviction mean that the balance of rights in these cases is tilted unfairly away from tenants. While the grounds are discretionary, the opportunity is still there for unscrupulous landlords to take advantage of the imbalance to unfairly evict tenants. While I'm in favour of much of the thrust of Part 2 of this bill, which tightens the circumstances under which eviction should be allowed, I believe that there is further to go in ensuring that the balance of rights is fair. That's why I'm supportive of all of the amendments in this grouping that make it more difficult to allow unfair evictions. However, my amendment here allows the Government to review the structure under which such unfairness can take place. This amendment deals with the cause of the imbalance, while the rest of the bill attempts to mitigate the effects. We've all heard of stories where tenants having been told that the landlord intends to put the property on the market, find that they have been evicted, and then find the property put back up for rent, often at a higher price. All of my amendments in this part of the bill seek to ensure that the balance of rights is reweighted towards the tenants, while still allowing landlords the ability to end a tenancy where there is a legitimate need to do so. I think that the time has come to review the grounds for eviction so that the Government can properly consider them in the light of the time that has passed and the experience that has been gained in the application of the grounds since the 2016 Act and the subsequent amendments to its schedule have come into force. I do take on board the Government's commitment to undertaking that review, and that the timescale of 12 months might be overly restrictive in terms of consulting and giving a full perspective of the changes that are required, and so don't intend to press these amendments. On Amendment 502, that stops landlords evicting tenants under no-fault circumstances for 12 months after they've carried out work as a result of a grant made under the Eco4 scheme. In a 2023 Scottish Government report estimated that by March 2024, nearly half of households in the private rented sector will be living in fuel poverty. Now, the Eco4 grants are part of the UK Government's strategy to meet carbon emission targets and reduce the impact of the current cost of living crisis. They focus on households that are deemed to live in fuel poverty. Grants are means tested to the tenant's income, no relation to the situation of the landlord. And if a landlord receives a grant to make improvements to the energy performance of the home, the decision has been taken to award the grant because of the tenant, not the landlord's financial circumstances. The tenant in question, having been the reason why the landlord got the grant and having had the inconvenience of any work being made to their home, should then, I think, be given more protection from eviction, so that they get the intended benefits of the improvement to the property, rather than the landlord being able to evict and then often reletting a property at a higher price due to the improvements which have been funded by government because of the circumstances of the tenant. Now, I appreciate the points that the Cabinet Secretary makes, so don't intend to press at this point, but I do think there is a gap in the legislation and how we deal with that, whether that be at a UK level or a Scottish level. I'm happy to have those further discussions to essentially iron out that anomaly of a landlord getting funding to improve a property on the basis of a tenant's circumstances and then evicting them to relet. Yep, certainly.
Thanks for taking the intervention. I just wonder whether this is best dealt with at a UK level, and that conditions should be attached to the issuing of a grant, which would tackle the issue that Mr Griffin raises.
I'm not opposed to the conditions being attached to the grant. I'm not aware of the legal discussions that have gone on in relation to that scheme and whether there are difficulties between reserved and devolved competencies in terms of the laws on housing, evictions and other areas. So, like I said, I'm happy to have a discussion with the Government as to how the legal interaction between reserved and devolved competencies competencies interact there. So happy to not press and leave that to further discussion, potentially for stage 3. And the amendments in the name of my colleague Katie Clark, Amendment 409 aims to strengthen the criminal law relating to unlawful eviction and the action which can be taken against the worst landlords, in particular repeat offenders. Freedom of information requests from the Legal Services Agency to the Crown Office Procurator Fiscal Service revealed that of the 153 complaints it received of unlawful eviction in the 5 years to the 31st of March 2018, it proceeded against only 56 to 59 people. Such proceedings resulted in a minimum of 3 and a maximum of 12 convictions annually. At the time of a 2020 publication from the Legal Services Agency, the first tier tribunal had made an award of damages for unlawful eviction only once in its entire history. But Amendment 409 seeks to tighten the legal provisions against unlawful evictions by amending the 2016 Private Housing Tenancies Act to create a wrongful termination offence which criminalises the act of misleading a tenant into ceasing to occupy a let property. It allows for a defence where an individual had not intentionally misled the tribunal or the tenant. An individual guilty of this offence on a summary conviction would be liable to a fine not exceeding the statutory minimum, or to a 6-month maximum custodial sentence, or to both. If guilty on conviction on indictment, the individual would be liable to a fine or to imprisonment for a maximum 2-year term, or to both. This is an attempt to strengthen the penalties in the most extreme cases. On Amendments 413, 414, further to the previous amendment, Amendment 413 also seeks to strengthen deterrence against unscrupulous actions by landlords by setting higher penalties under wrongful termination by eviction orders. This amendment increases the maximum penalty for wrongful termination. This amendment also increases the cumulative total that the tribunal may require landlords to pay from 6 months to 36 months. Amendment 414 relates to the sale of an occupied property on the grounds of sale only to later seemingly abandon those plans to sell. 2022 research from Generation Rent found that, despite tenancy reforms, nearly a third of private landlords who evicted tenants in order to sell the property failed to sell the home more than a year later, with 9% of cases of tenants being evicted on grounds of sale who saw the home simply sold to another landlord who re-let the property. Therefore, Amendment 414 adds protections on property sale which restricts landlords from letting or attempting to let the property in question within 12 months of an eviction order being granted. Those cover the amendments in my name and Katie Clark's name, but also wanted to touch briefly on the amendments in the name of Megan Gallagher as it relates to protections on terminal illness, and just to support the work that Megan Gallagher, the Cabinet Secretary, and Marie Curie have done in this area, and I'm hopeful that we can reach a consensus and a strengthening of protection for those who are terminally ill and their families. I also wanted to touch briefly on the issues raised by Willie Rennie, Fulton Gregor and Megan Gallagher on the use of properties which are held by religious organisations. Now, in general, my general principle would be that I would agree with Maggie Chapman's comments that the organisations which hold the property shouldn't dictate how easy it is or not to evict. But when that leads to these properties lying empty, especially when it's the large family-sized properties that we know we are crying out for use, then I think this is another area that I think it would be helpful for the government to look at, to give those organisations the comfort to be able to let those out, relieve the pressure that exists, with the assurance that they can bring them back into use for employment for a minister or priest or any other employee. Happy to end my contribution there.
Do any other members wish to speak at this moment? Okay. Megan Gallagher, to wind up and press or withdraw Amendment 119.
Thank you, very much, Convener. There's been a lot of really important issues that have been raised in this section when we're talking about dealing with evictions, and I am grateful to the Cabinet Secretary for her time and the conversations that we've had in relation to my amendments that deal with terminal illness, and working alongside Marie Curie and of course other colleagues who have been involved in those conversations as well. I think it shows the resetting of the housing bill in terms of conversations, working relationships, cross-party, and I do welcome the opportunity to have further discussions with the Cabinet Secretary over the summer, and I do hope that that would of course involve Marie Curie as well, who are the organisation that's been behind the amendments today. If I may touch upon the amendments that relate to religious organisations being able to let out properties. I do believe this is a really important issue. I understand, of course, this was legislation that was brought in during the pandemic, but again, there's a legacy issue here, I believe, in terms of looking to see how we can find that balance between letting those homes, but also making sure that when those homes need to be occupied by a minister of the local church congregation, that also can happen as well. I don't believe that this would be an issue that we can resolve necessarily overnight, but I think Ross Greer's suggestion in terms of the Cabinet Secretary meeting with religious groups and organisations would be a step in the right direction to see what we can do to tease out some of the issues that have been raised. I think we also need to look at the tribunal. I think when it comes to the tribunal's powers in terms of what it can do, I think something that's been made clear in terms of stage 1 but stage 2 of the housing bill as well is how do we strengthen those powers of the tribunal in terms of what overall authority they have to strengthen tenants' rights, but also be able to look from a landlord's perspective in terms of have they followed the correct processes, and if they do, how do they make sure that they find a suitable resolution to any issues that are being raised through those means. Again, it's something that have been raised through various different amendments by members today, certainly in relation to evictions, the section that we're dealing with. I am sympathetic to Maggie Chapman's amendments when she's speaking about winter evictions. I think the problem that I have and where I'm positioned is how do you define winter, for example. I know that's something that perhaps Maggie Chapman does want to explore, but I do believe that with the climate that we have in Scotland, that is going to be incredibly difficult to work out. We have some summers that look like winters, for example, and what you could end up with is a year-long process where it doesn't allow any of the eviction processes to happen. Now, I understand that could be the position that Maggie Chapman is wanting to set out, and that's, of course, within her right to do so. But I think there has to be a balance because, of course, there are situations where landlords do need to take back the property. And I do believe if we put in measures such as winter evictions as an example, that could prevent genuine situations from happening in that respect. Yes.
Specifically the 4 months over winter, so November, December, January, February. So that is clear. So I'm not saying it needs to extend to awful weather at other times of the year. It's a winter eviction.
I take on board the comments that Maggie Chapman is making. As again, as said, I am sympathetic given the climate that we have in Scotland and given the situation that people could be faced with. But I think you've got to balance that up with what our climate is like generally in Scotland, and I think there could be means to expand that, given that we do have extreme weathers throughout various different parts of the year. I know that Maggie Chapman is saying that that's not the intention behind the amendment, but I do feel that that could be the starting point for the expansion of that in itself. In relation to Mark Griffin's amendments, again, I understand what he's trying to do. I think Graham Simpson made a really important point in terms of, would that be UK level in terms of grants instead of it being dealt with here within the housing bill. However, I do believe that given that it does surround tenants' rights, it does surround housing in general, that it was right to bring forward an amendment, even if Mark Griffin decides not to press that amendment today. I understand time is ticking on, Convener, so I'm going to leave my remarks there, but I seek to withdraw Amendment 119. Thank you.
Thank you. Megan Griffin seeks to withdraw.
Gallagher.
Sorry. All right, that's interesting. Yeah, right. Sorry about that. Megan Gallagher seeks to withdraw Amendment 119. Does any member object to the amendment being withdrawn? There are no objections, so the amendment is withdrawn. I call Amendment 120 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not move, convener.
I call Amendment 122 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 123 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 491 in the name of Fulton McGregor, already debated with Amendment 119. Fulton McGregor to move or not move?
Not moved.
I call Amendment 124 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 125 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 163 in the name of Edward Mountain, already debated with Amendment 119. Edward Mountain to move or Megan Gallagher on behalf of Edward Mountain to move or not move?
Moved, convener.
The question is that Amendment 163 be agreed. Are we all agreed?
Yes.
No, we're not agreed. There will be a division. All those in favour of Amendment 163? All those against? The result of the division on Amendment 163 is 2 for, 5 against. The amendment has been disagreed. I call Amendment 452 in the name of Willie Rennie, already debated with Amendment 119. Willie Rennie to move or not move?
Not moved.
I call Amendment 487 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 126. Oh, the question is that Section 224 be agreed. Are we all agreed?
Yes.
I call Amendment 126 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 127 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 128 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 129 in the name of Megan Gallagher, already debated with Amendment 119. Megan Gallagher to move or not move?
Not moved.
I call Amendment 164 in the name of Edward Mountain, already debated with Amendment 119. Megan Gallagher to move or not move?
Moved.
The question is that Amendment 164 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. All those in favour of Amendment 164? All those against? The result of the division on Amendment 164 is 2 for, 5 against. The amendment has been disagreed. I call Amendment 165 in the name of Edward Mountain, already debated with Amendment 119. Megan Gallagher to move or not move?
Moved.
The question is that Amendment 165 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. All those in favour of Amendment 165? Those against? The result of the division on Amendment 165 is 2 for, 5 against. The amendment has been disagreed. The question is that Section 25 be agreed. Are we all agreed?
Yes.
I call Amendment 166 in the name of Edward Mountain, already debated with Amendment 119. Megan Gallagher to move or not move?
Moved.
The question is that Amendment 166 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. Those in favour of Amendment 166? Those against? The result of the division on Amendment 166 is 2 for, 5 against. The amendment has been disagreed. The question is that Section 26 be agreed. Are we all agreed?
Yes.
I call Amendment 167 in the name of Edward Mountain, already debated with Amendment 119. Edward Mountain to move or not move?
On behalf of Edward Mountain,
I'm
not
sorry.
moved.
Thank you. We're just getting notes here as well. Okay, thank you. Did you say not moved?
No, sorry, moved.
Moved.
Sorry,
Yeah,
moved.
moved. Okay.
No, I'm getting confused.
The question is that Amendment 167 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. All those in favour of Amendment 167? All those against? The result of the divisions on Amendment 167 is 2 for, 5 against. The amendment has been disagreed. The question is that Section 27 be agreed. Are we all agreed? Yes. I call Amendment 187 in the name of Maggie Chapman, already debated with Amendment 119. Maggie Chapman to move or not move?
Moved.
The question is that Amendment 187 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. All those in favour of Amendment 187? And those against? The result of the division on Amendment 187 is 2 for, 5 against. The amendment has been disagreed. I call Amendment 188 in the name of Maggie Chapman, already debated with Amendment 119. Maggie Chapman to move or not move? Move. The question is that Amendment 188 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 188? Those against? The result of the division on Amendment 188 is 2 for, 5 against. The amendment has been disagreed. I call Amendment 250 in the name of Emma Roddick, already debated with Amendment 119. Emma Roddick to move or not move?
Not moved.
I call Amendment 251 in the name of Maggie Chapman, already debated with Amendment 119. Maggie Chapman to move or not move?
Moved.
The question is that Amendment 251 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. Those in favour of Amendment 251? Those against? The result of the division on Amendment 251 is 2 for, 5 against. The amendment has been disagreed. Call amendments 362, 363, 364, 365, 366, 367 and 368, all in the name of the Minister and all previously debated with Amendment 119. And I invite the Cabinet Secretary to move amendments 362 to 368 en bloc.
Moved on block.
Does any member object to a single question being put to amendments 362 to 368? No. Okay. The question is that amendments 362 to 368 be agreed. Are we all agreed? The question is that section 28 be agreed. Are we all agreed? I call Amendment 369 in the name of the Minister, already debated with Amendment 119. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 369 be agreed. Are we all agreed? Yes. I call Amendment 268 in the name of Mark Griffin, already debated with Amendment 119. Mark Griffin to move or not move? Not moved. I call Amendment 269 in the name of Mark Griffin, already debated with Amendment 119. Mark Griffin to move or not move?
Not moved.
I call Amendment 114 in the name of Emma Roddick, already debated with Amendment 119. Emma Roddick. Oh, sorry. I call Amendment 141 in the name of Emma Roddick, already debated with Amendment 119. Emma Roddick to move or not move?
Not moved.
I call Amendment 409 in the name of Katie Clark, already debated with Amendment 119. Mark Griffin to move or not move.
Not moved.
I call Amendment 502 in the name of Mark Griffin, already debated with Amendment 119. Mark Griffin to move or not move.
Not moved.
I call Amendment 413 in the name of Katie Clark, already debated with Amendment 119. Mark Griffin to move or not move.
Not moved.
I call Amendment 414 in the name of Katie Clark, already debated with Amendment 119. Mark Griffin to move or not move.
Not moved.
I call Amendment 442 in the name of myself, already debated with Amendment 254, and I move that amendment. Already debated with Amendment 257, and I move that. I move that amendment. The question is that Amendment 442 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 442? All those against? The result of the division on Amendment 442 is 2-4, 5 against. The amendment has been disagreed. And at that point, I am going to invite us all to suspend the meeting and have a 10-minute break. Thank you. begin when we've gone from a suspension? Welcome back. Welcome back. We're going to start with the next grouping, which is called Tenants' Rights to Keep a Pet. And I call Amendment 522 in the name of Emma Roddick, grouped with amendments as shown in the groupings. And I remind members that Amendments 523 and 24 and Amendments 532 and 28 are direct alternatives. That is, they can both be moved and decided on. And the text of whichever is the last agreed to is what will appear in the bill. Emma Roddick to move Amendment 522 and speak to other amendments in the group.
Thank you, Convener. As somebody who lives with a cat and has struggled to find landlords who are happy with that, I'm really excited about the fact that this bill is strengthening the rights of tenants to keep pets. And my amendments just seek to provide that certainty to tenants as soon as possible. 523 changes the period landlords have to respond to the pet request from 42 to 28 days. And having spoken with the Cabinet Secretary about this and explored the likelihood of forcing an answer before the landlords had a chance to take everything into account, leading to an unnecessary no, I do understand that there are debates around the best time frame to go with, and on that basis I will not press, and I'm happy to rethink this before stage 3 to ensure that the balance is in the right place. Some of my other amendments, along with Maggie Chapman's, remove reference to assumed refusal, as both of us believe that a non-response should be considered consent. I am aware that we're going to discuss property factors in a later group, and that is one of many reasons that I'm concerned about the burden on the first-year tribunal, where it's clear that a tenant has or can comply with reasonable conditions for keeping a pet and the landlord has not refused but has simply failed to give consent. I don't believe that it would be a good use of anyone's time for the tenant to then have to challenge the default refusal through a tribunal while others are waiting to hear back on unreasonable conditions. I also believe that unless there are considerable, reasonable reasons that a tenant cannot keep a pet or that the property is simply not suitable for that pet, then there's not a good reason for the landlord to make such a refusal, and the tenant should be very clear why a refusal has been made in any circumstance. Thank you, Convener.
Thank you, Emma. Now I call Maggie Chapman to speak to... Oh yes, could you move your amendment?
I move the amendment.
Thank you very much. Maggie Chapman to speak to Amendment 259 and other amendments in the group.
Thank you, Convener. And this is another fairly, not too lengthy, but fairly lengthy contribution from me. I know many members of the committee, indeed many members of Parliament, are pet owners and animal lovers. Emma Roddick entered the Holyrood Dog of the Year competition earlier this month with her beautiful English Bull Terrier, Sparky, as did Megan Gallagher with Dogs Trust dog Trevor. Pets make a house a home. And that's what this part of the bill is trying to do by setting up a clear framework for tenants to make requests for their pets to live with them as part of their family. There is a lack of pet-friendly rented homes in Scotland. A 2021 survey of landlords, letting agents and tenants on pets and rental properties conducted by YouGov on behalf of Cats Protection and Dogs Trust found that 68% of private Scottish landlords who don't currently allow pets in any or all of their properties say nothing would persuade them to do so. This demonstrates the need for a legal framework to actively encourage landlords to see the benefits of pet ownership for responsible tenants. Additionally, the survey highlighted the number of blanket no-pet policies in Scotland. 18% of Scottish landlords do not allow cats because they use a standard template contract provided by the letting agent. 6% do so because they use a standard template contract which they download. Currently, tenants are being denied the opportunity to experience the benefits of pet ownership simply because their contract says no to pets. The proposals will end blanket no-pet policies by allowing tenants to request to keep a pet without fear of automatic rejection because of a contractual clause. Giving responsible tenants the right to request to keep a pet in their home, which landlords cannot unreasonably refuse, will decrease the burden on animal rehoming organisations, such as Cats Protection. In 2023, Cats Protection took in the equivalent of around 3 cats each day, due to landlords not allowing them in their properties. The current proposals have the potential to help relieve the large wait lists faced by rehoming organisations and allow them to focus their resources on other animals in need. I have a number of amendments to make this process work better, and these have all been developed in partnership with Cats Protection, Dogs Trust and Sight Scotland. Amendments 24 and 28 reduce the time a tenant has to wait to get a response to a pet request from 42 to 14 days. Dogs Trust believes this would allow tenants to better plan for pet ownership, reduce any kennelling or cattery expenses, and lessen the significant stress of not knowing if they'll be able to keep their pet in their rented property. From the landlord's point of view, this would still afford a reasonable timeframe within which to consider the request. Amendment 26 addresses a loophole in the proposed system. If a landlord does meet the timescales, they are currently deemed. If a landlord does not meet the timescales, they are currently deemed to have refused, which is simply not fair. They have no way of knowing why the landlord does not consent to the pet, and therefore no ability to offer assurances to the landlord or otherwise to challenge the decision. Amendment 26 changes this, so that the landlord is deemed to have consented if they do not reply within the timescales. This is not something new and not an untested formula. It is the same approach that appears in Section 30 for social housing. There is no good reason at all why social and private tenancies shouldn't be treated exactly the same in this respect. It's very important that all parties are clear on what does and does not constitute a reasonable request and a reasonable refusal. So Amendments 26 and 27 require ministers to produce the appropriate guidance for these. My amendments 259 to 261 and 263 to 265 cover assistance animals. These exempt assistance animals from the pet request process, granting an automatic right to have an assistance animal in a rented property. I have heard concerns that my amendments are already covered by the Equality Act. It, of course, prohibits discrimination against disabled people, but there are no specific protections for disabled tenants who need their assistance animals at home. Sight Scotland reports having to work with the landlords of blind and partially sighted people to ensure that their assistance animals can live with them. If the Equality Act was perfectly clear on this point, this clearly would not be happening, but it is. I would like to provide a quote from a person with sight loss living in Edinburgh, who has repeatedly been refused a tenancy because they need their guide dog to live with them and have been told no. And this is the quote. "It was very disheartening when I was told that I couldn't rent a property because of my guide dog. It made me feel very upset and frustrated. Even when I explained the laws and legislation, I was still told no, and that the letting agent had to take the landlord's side. It made me very wary of looking for a rental property, and I started to discount a lot of properties, as the adverts stated, no pets. This left me with a very limited choice of houses to pick from. The stress of finding a property is bad enough, without having to explain my sight loss and why I have a guide dog as my mobility aid. Disabled people should not be made to jump through the hoops of the Equality Act to prove that it covers having their assistance animal with them in their home. There should instead be a very clear and simple statement in Scottish housing law confirming that they can. This is what my amendments seek to do. I'm very pleased to have the support of the Health and Social Care Alliance, Guide Dogs and Sight Scotland for these amendments. Thank you, Convener.
Thank you. Cabinet Secretary to speak to Amendment 370 and other amendments in the group.
Thank you, Convener. Amendments 522 and 564 in the name of Ebba Roddick would provide for a new appeal route if a private landlord withdraws consent for a pet because the tenant has not complied with the reasonable conditions imposed. There are already existing routes of recourse in the private rented sector through the first-tier tribunal in relation to a breach of the tenancy agreement, which could be used in these circumstances. Whilst I think these amendments are unnecessary, I do appreciate the members' desire for clarity around this issue because it is exceptionally an important point. So guidance for tenants and landlords will be important in supporting these new rights, and further support around this type of issue will be addressed through that guidance. I would give the member the reassurance on that point and therefore ask her not to press. Amendments 259 and 263 and the associated amendments 260, 261, 264 and 265 in the name of Maggie Chapman would allow private and social tenants to keep an assistance animal without the consent of the landlord. While I am sympathetic to the outcome sought, I don't think these amendments are necessary. This is because a disabled tenant can already ask a landlord to keep an assistance animal. If the tenant requires any such animal, these cannot be unreasonably refused. This is known as making a reasonable adjustment under the Equality Act. These amendments, while well intended, will likely confuse matters as they do not take account of the needs of other tenants or the suitability of the property. We can address the issue which Maggie Chapman raises today around guidance, convener, and I also believe that that it's now easier to seek redress through the tribunal, again to recognise the concerns that Maggie Chapman raises, but suggesting there is another way to do this.
On that point, I understand what the Cabinet Secretary is saying, but surely a disabled person shouldn't have to go through a tribunal. They should not be put through that additional hurdle to have living with them the animal that allows them to function in society. I think that is another burden. It's more bureaucracy that we wouldn't ask of somebody who was not disabled. Why are we asking it for somebody who's disabled?
Well, I agree. It shouldn't get to the point of going through a tribunal, which again goes back to a point we've raised on many issues around this, is about being able to support tenants in a better recognition of their own rights and indeed landlords of their obligations. We also need to take account, for example, in the private rented sector, about the importance, for example, around shared accommodation and allergies of other tenants that are areas where we do need to take those aspects into account. So again, I completely appreciate where Maggie Chapman is coming from on this issue, and the case studies which she mentioned there are clearly very concerning, which is why I think it is important that we can do further work on both the rights of the tenants and the responsibilities of landlords on these issues. I remain persuaded, unfortunately, however, that these amendments are not necessary, and there are other ways that we can achieve the outcome, which I think both myself and the member do wish to achieve. Amendments 523 and 532 in the name of Emma Roddick and Amendments 24 and 28 in the name of Maggie Chapman seek to reduce the period within which landlords must respond to a pet request. We recognise that pets are an important member of people's families and believe tenants should be able to benefit from the experience of pet ownership, as is the case for most other households, as indeed my own household does as well. Amendment 523 would reduce the period for private landlords to respond to a pet request from 42 to 28, and Amendment 24 would reduce the period to 14 days. I'm concerned that reducing the period to 14 days may result in disputes which could have been avoided with a slightly longer period. Even if a landlord is content to agree to a request, the landlord might have further questions. Making sure there is enough time for the landlord and tenant to discuss the request will help both parties. The landlord might otherwise be unable to consent only because there's not been enough time to agree reasonable conditions. We consulted as part of our landlord and tenant engagement questionnaire on the appropriate timescales for a landlord to respond. In setting the timescale at 42 days, we tried to strike a balance between providing landlords with a reasonable timescale to consider a tenant's request and respond, but which is not unreasonably long from a tenant's perspective. The timescale is also aligned with those for considering a request to make a Category 2 change to the property. But I do recognise that there are concerns, including from many animal rights charities, that 42 days is too long. And I am therefore happy to work with both members to consider this timescale again for Stage 3. On that basis, I would ask members not to press. Amendment 532 would reduce the period for social landlords to respond to a pet request from 1 month to 28 days, whereas Amendment 28 would reduce the period to 14 days. I am concerned that reducing the period to 14 days may result in unnecessary disputes in a similar way to the private sector. The period of 1 month is a bit more onerous than 42 days afforded to the private sector, but this was considered reasonable given that social landlords already respond to some other requests from tenants within a month, such as requests to take a lodger, to sublet or assign the tenancy, or to exchange house. I think it is helpful for social landlords to have a consistent period for responding to such requests, but I am happy to discuss this matter again with members further, and on that basis I would ask them not to press. Turning to Amendment 25 in the name of Maggie Chapman, this would change the provision so that where a private landlord fails to respond, the request is automatically approved. I am concerned that there would be negative consequences of an assumed consent model in the private rented sector. For example, it would be difficult to remedy disputes in cases where a landlord has not responded or appeared not to have responded to a request in the timeframe, but where there was a legitimate reason for a delayed response. If the tenant had assumed consent and already obtained a pet in the interim, this would create significant issues, and I would ask the member not to press this amendment on that basis.
Intervention just on that. So I appreciate the potential issue that she highlights with this, but surely the flip is true as well. If a landlord doesn't respond and therefore you have assumed a refusal, then the tenant has absolutely no way of seeking to appeal that decision, seeking to challenge that. That's how this is currently presented. That might not be the intention, but that is how it is currently presented. And I think there may be reasons why a landlord is happy for a renter to have a pet but hasn't responded, and then the tenant thinks they haven't met that deadline. I've got nothing left.
Well, I would say that the tenant can appeal an unreasonable refusal. So I hope that reassures Maggie Chapman that there is an ability to appeal there. My concern goes, as someone who has a pet as a member of the family, that we would be asking people to have to send their pet to rehoming or to find alternative accommodation for what is in effect a member of their family. So my concern is, as an animal lover and a pet owner, that the issues that are raised with assumed consent, I think, would be quite concerning for the tenant and indeed for the pet. Amendments 524 to 527 in the name of Emma Roddick would remove the ability of a tenant to seek redress where a landlord has failed to respond to a pet request. I understand these are amendments intended to support the effective operation of the deemed consent model proposed under Amendment 25. And I've already set out my concerns and the risks that I think this model would create. I don't think this is the right way to deliver improved rights in this area, so I would ask the member not to press. Sure.
Does she recognise that in many situations the pet will already exist? The person who's seeking to rent the property already has the cat or dog and is possibly leaving them with a family member in limbo, perhaps in a cattery or dog kennel, waiting to hear for what's going to happen with the landlord?
I would, and that's why I'm more than happy to work with yourself and with Maggie Chapman on the timings of how long some of these decisions can and should take, because I appreciate both the terms of whether it's support from the pet, company from the pet, or indeed the costs of the cattery, kennels, etc. Can be quite substantial over even a short period of time. So I think what Emma Roddick and Maggie Chapman's amendments in terms of the timings of these decisions have importantly raised is that while, as I've set out, there were reasons for the timings that the government has proposed, we probably haven't got that, well, we have not got that balance correct, and I'm more than happy to see what can be done before stage 3 to try and alleviate some of those concerns, to assist with the points that Emma Roddick has just made. Amendment 370 in the name of Paul McClellan is a minor technical amendment correcting a previous typo, which makes no change to the effect of the provision. Amendments 168 to 172 and Amendments 180 to 182 in the name of Edward Mountain relate to reasonable conditions for approval to keep a pet. I recognise Mr Mountain is seeking to provide some greater clarity and certainty on the face of the bill on ensuring ministers make the use of regulation-making powers provided in the bill and on some detail that they should cover. For example, setting out that it would be a reasonable condition for approval for the landlord to require the tenant to have the property professionally cleaned at the end of a tenancy. I can assure members that in order to make these additional rights operational, regulations will need to be brought forward to set out the further detail. The details of what would be considered an unreasonable refusal or reasonable conditions for approval must be developed in consultation with both landlords, tenants and other relevant stakeholders, and I firmly believe that this is the right approach. That's why the bill specifically includes statutory provisions that require consultation for the exercise of the regulating making powers under the affirmative procedure. We will include the areas highlighted by these amendments in that work and would therefore ask Mr Mountain not to press. Amendments 26 and 27 in the name of Maggie Chapman would change the bill so that Scottish ministers must make use of the regulation making powers in the bill to set out when it is reasonable for a landlord to refuse to consent to a tenant keeping a pet. I can reassure members of the committee that while the current drafting of the provisions say may, making use of the regulation making powers will be an essential part of the implementation. Effective guidance will be essential to the successful implementation of those measures, as will ensuring landlords are provided with sufficient information to inform their decisions, and I therefore ask the member not to press. Turning to the other amendments in the group, which are in the name of Emma Roddick, Amendments 528 and 529 seek to provide greater clarity and certainty on the face of the bill. Current provisions in the bill already mean that refusal and any consent conditions must be reasonable, which is the appropriate test, and Amendment 528 is therefore not needed. Turning to 529, which includes aspects that the regulations may cover, I also don't believe this amendment is necessary. As I've made clear, we are committed to consulting further with landlords and tenants on the detail that should be included in regulations under the affirmative procedure to support the operation of the new rights. There is already a duty on the face of the bill in connection with this, and can reassure members that the aspects covered in this amendment will also form part of that work. On that basis, I would ask Ms Roddick not to press the amendments. Amendments 530 and 531 relate to the refusal of a request to keep a pet by a social landlord. They would make it a condition that landlord refusal is necessary and proportionate, and there is clear reasoning or supporting evidence. A tenant who is unhappy about the landlord's decision to refuse their request can appeal using the landlord's complaints process and has a further route of redress beyond this to the SPSO. I believe that any additional conditions for refusal going forward are best developed through consultation and engagement once again with the sector and set through legislation. Amendment 533 seeks to provide that where a social landlord fails to respond to a pet request within the period required, the landlord is deemed to have consented. What the member is seeking is provided for by new paragraph 8H, which is inserted into the Housing Scotland Act 2001 by section 33 of the bill. On that basis, I don't think that anything more is needed to deliver what is being sought, and would therefore ask the member not to press. 534 and 563 would provide for a new appeal route if a social landlord withdraws consent for a pet because they have not complied with the reasonable conditions imposed. All social landlords provide their tenants with written tenancy agreements which set out their tenancy obligations, including the conditions the tenant is required to adhere to relating to keeping pets. Any breach of tenancy conditions could result in appropriate and proportionate action being taken by the landlord, which could include withdrawal of consent to keep a pet where necessary. I believe that if any changes are required to the existing process for withdrawal of consent by social landlords, this is best developed through consultation and engagement with the sector and through secondary legislation following public and parliamentary scrutiny, and would therefore ask Ms Roddick not to press. In summary, and for the reasons I have set out, I would ask Emma Roddick, Maggie Chapman and Edward Mountain not to press their amendments in this group. Thank you, Convener.
Thank you. And I call Megan Gallagher to speak on behalf of Edward Mountain to Amendment 168 and other amendments in the group.
Thank you very much, Convener. 168, as the Cabinet Secretary has set out, this amendment would make it a duty for Scottish ministers to make provisions about when it is reasonable for a landlord to refuse to consent to a tenant keeping a pet at a let property. This amendment is about clarity. I think, similar to other amendments in this particular grouping, it's about knowing what is fair, what is reasonable, but also making sure that landlords know what perimeters that would mean in terms of context. And again, similar to the ones that have been submitted in terms of allowing the tenant to know why perhaps a pet has been refused from a property. Going on to Amendment 169, amendment gives the landlord the ability to reasonably refuse consent for pets to be kept at a property if the landlord has a medical reason for doing so. Now, I think this one is very important because, again, I think landlords, you know, I think it was Maggie Chapman that said 18% of landlords say that they don't allow for a pet at present. I do believe there will be a small proportion of those who perhaps have allergies to cats or dogs, and that could be a justifiable reason, in my view, for not allowing a pet at that property, particularly if the allergies are severe. And what Edward Mountain is attempting to do here, again, is strike that reasonable balance, as by not saying no to pets, but again, if the landlord owns that property and has to visit that property for checks and other reasons, then that would be, in my view, a justifiable reason for not allowing the pet in that property in those circumstances. But again, I would imagine that that would be relatively small in number instead of being widespread across the private rented sector itself. In terms of 170, this amendment makes it a duty for Scottish members to make provisions about when a landlord's consent condition for keeping a pet at let property is reasonable. So again, that relates to Amendment 168 and 171. Scottish ministers must by regulations make a provision about when a condition specified in a landlord's notice is reasonable. Again, I think that's about creating that further clarity and further guidance for landlords as well, should there be changes to the bill in this respect in relation to tenants' right to keep a pet. 172 of Edward Mountain's is that a landlord can reasonably make it a condition that when she consents for pets to be kept at a let property, any carpeted floors or soft furnishings must be professionally cleaned by an independent company at the end of the tenancy. Again, what Edward Mountain is seeking to do with these particular amendments is, you know, put that pet ownership responsibility into the face of the bill. I think there is an element of that, you know, particularly if you do have a pet who sheds, for example, that could obviously lead to a need for carpets, other soft furnishings to be cleaned. And again, 172 seeks to address this. If I may, of course,
and
yes, of course.
I appreciate these aren't your own amendments, so you're speaking on behalf of Edward Mountain. But one of my concerns, I think, with amendments 172 and 182 on the professional cleaning are just the costs of those. And I wonder whether, in conversations between now and stage 3, Edward Mountain would consider amending that slightly to say professional, or, you know, have it cleaned in another way to a similar standard, just to make sure that the tenants aren't liable for extortionate costs. The other element is exempting assistance animals from those costs as well, whether there's room for conversation in that space.
No, I understand exactly what Maggie Chapman is saying here. Of course, I don't want to preempt what my colleague is saying. I'm certain that he would like to bring these amendments or similar amendments back at stage 3, you know, so he can speak to them himself, given that he's not been able to attend committee for reasons that I've put forward at another committee meeting on the Stage 2 bill. But I can certainly, through the conversation that we've had just now, take that back to Edward Mountain. But again, as these are his amendments, I don't think it would be right for me to come to any conclusion in that respect. On 180, I thought I was going on to talk about other amendments there, but on 180, it makes a duty for Scottish ministers to make provisions about consent condition for keeping a pet and what makes that reasonable. Again, that's seeking more clarity in 182. We've just discussed in terms of an exchange there with Maggie Chapman in relation to carpeted floors and soft furnishings being professionally cleaned by an independent company at the end of the tenancy. Again, I think that's about pet responsibility, pet ownership, but probably what you would perhaps do in your own home at times, you know, should a pet, you know, cause any reason for that, for those furnishings to be cleaned themselves. If I may turn to other amendments in the grouping, just because it is something that I care about myself. Maggie Chapman was absolutely right. I have entered a Dogs Trust dog every year, bar one, when I was on my maternity leave, because I do believe in what they're trying to achieve in terms of making it easier for people to own a pet, and of course making sure that animals don't end up at rescue homes, whereas they can actually have a forever home. And I think that's something actually that most members in this committee would support. The issue that I have with amendments 24 and 28, and they're not issues as such, I think it's more just in terms of what, in terms of time frame, is acceptable or reasonable. Is it going to be 14? Is it going to be 28? Is it going to be something else? I don't think that's something that necessarily we can determine here at this particular committee meeting today. I think what might need to happen is another discussion. I know we're going to be having a lot of discussions, but another discussion to work out what is fair and reasonable. Could 14 days, for example, and this is just something that I'm coming up with just now when we're looking at this, you know, the landlord could be on holiday for 14 days, they could be ill, there could be another personal circumstance that might not give them sufficient time to respond. I understand there could be works around for that, but again, that would just be me looking at it from a 14-day perspective. Would 28 days be far more reasonable? That was something that I was discussing with Dogs Trust at the beginning, or should it be another time frame? I think that's something that we can all have a good debate about as we approach stage 3, because it is important. 25 in terms of being automatically approved. Again, I think we need to determine what time frame is appropriate before looking at this amendment, but I understand the reasonings and I'm very sympathetic to it, given the points that I've raised in relation to people having the right to own a pet. And I think that, again, is something that a lot of us here in committee do support in principle. I think we also need to look at the type of pet as well. This is something that's been touched upon briefly in amendments, but maybe not so much, because I think there is a massive difference between a border terrier dog, for example, in terms of a difference of a Siberian Husky. I'm not trying to say which one is my favourite, because I've got friends who own both types of dog, but I think we need to look at this as well in terms of, you know, what impact would that have in terms of a small rental property, and whether that would be seen as an appropriate place to have such a large sized dog. And I think that's something that we've got to be mindful of as well when we're looking at the face of the bill. And in relation to Maggie Chapman's amendments on assistance animals, I do take the point that the Cabinet Secretary is made in relation to the Equality Act, but I would be interested to see if that covers additional animals such as therapy pets, you know, just as another one. I'm not entirely sure, this is why I'm throwing it out here, but I think that's something else that we'll need to look at as we approach stage 3, whether it would be guide dogs for sight, hearing loss, for example, just thrown out too, or whether that would cover other therapy pets as well. Convener, I'll leave my comments there. I think I've addressed all of Edward Mountains, but certainly one that I have interest in as well in terms of this section. Thank you.
Thank you. Do any other members wish to speak? Okay. Emma Roddick, to wind up, press or withdraw Amendment 522.
I will withdraw the amendment, but I do want to be clear that I still remain concerned about some of the aspects raised by amendments, both myself and Maggie Chapman's, in relation to the period of time that people are waiting in limbo, the ability of tenants to dispute the reasons that have been given for them not being able to have a pet, which I do believe is made much more difficult if there is no reason and it's simply a default refusal. And also what happens then when the person waiting in limbo relies on that animal to perform daily tasks. Thank you.
Thank you. Emma Roddick seeks to withdraw Amendment 522. Does any member object to the amendment being withdrawn? There are no objections, so the amendment is withdrawn. I call Amendment 259 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 259 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 259? All those against? And abstentions? The result of the division on Amendment 259 is 2 for, 4 against and 1 abstention. The amendment has been disagreed. I call Amendment 260 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 260 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. All those in favour of Amendment 260? All those against? Abstentions? The result of the division on Amendment 260 is 2 for, 4 against and 1 abstention. The amendment has been disagreed. I call Amendment 261 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Not moved.
Not moved. Call Amendment 523 in the name of Emma Roddick, already debated with Amendment 522, and I remind members that Amendments 523 and 24 are direct alternatives. That is, they can both be moved and decided on. The text of whichever is the last agreed to is what will appear in the bill. Emma Roddick, to move or not move?
Not moved.
Call Amendment 24 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 25 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 524 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 525 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 526 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 527 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 370 in the name of the Minister, already debated with Amendment 522. Cabinet Secretary, to move formally.
Moved.
The question is that Amendment 370 be agreed. Are we all agreed?
Yes.
I call Amendment 168 in the name of Edward Mountain, already debated with Amendment 522. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 168 be agreed. Are we all agreed?
Yes.
We are not agreed. There will be a division. All those in favour of Amendment 168? Those against? That one's going to pass. The result of the division on Amendment 168 is 4 for, 3 against. The amendment has been agreed. I call Amendment 26 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 26 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. All those in favour of Amendment 26? Those against? 26. The result of the division on Amendment 26 is 4 for, 3 against. The amendment has been agreed. I call Amendment 169 in the name of Edward Mountain, already debated with Amendment 522. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 169 be agreed. Are we all agreed?
Yes.
We are not agreed. There will be a division. All those in favour of Amendment 169? All those against? Abstentions? The results on the division of Amendment 169 is 3 for, 3 against and 1 abstention. What? Okay, divisions. Okay, as there is a tie, I must exercise a casting vote. And my casting vote is against the amendment. So the amendment has been disagreed. Disagreed. Yep. I call Amendment 528 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 529 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 170 in the name of Edward Mountain, already debated with Amendment 522. Edward Mountain to move, Megan Gallagher to move or not move?
Moved.
The question is that Amendment 170 be agreed. Are we all agreed?
No. Yes.
We're not agreed. There will be a division. All those in favour of Amendment 170? All those against? The result of the division on Amendment 170 is 4 for, 3 against. The amendment has been agreed. I call Amendment 171 in the name of Edward Mountain, already debated with Amendment 522. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 171 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. All those in favour of Amendment 171? All those against? The result of the division on Amendment 171 is 4 for, 3 against. The amendment has been agreed. Call Amendment 172 in the name of Edward Mountain, already debated with Amendment 522. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 172 be agreed. Are we all agreed?
No. Yes.
We are not agreed. There will be a division. Those in favour of Amendment 172? All those against? Abstentions? The result of the division on Amendment 172 is 3 against and 1 abstention. As there is a tie, I must exercise a casting vote, and my casting vote is a vote against the amendment. So the amendment is disagreed. Okay, we're going to move on to the next grouping, which is tenants' right to make changes to let property. And I call Amendment 173 in the name of Edward Mountain, grouped with amendments as shown in the groupings. Megan Gallagher, on behalf of Edward Mountain, to move Amendment 173 and speak to all other amendments in the group.
Thank you very much, Convener. If I may start with Amendment 173, submitted by Edward Mountain, and what he seeks to do with this particular amendment is that at the end of the tenancy, the tenant must return any Category 1 or Category 2 changes to the property to their original state before the change. What Edward Mountain is seeking to do, again, is to provide clarity and to ensure that landlords do not have additional expenses at the end of a tenancy should a tenant wish to make personalised changes to a property within Category 1 and Category 2. In relation to Category 1, I'm obviously referring to putting up posters, pictures, that type of adjustment. And category 2 would be things such as painting of walls, which can be very varying in terms of own personal taste and what colours you might seek to paint the walls. So again, I think this is about clarity for landlords and also to give reassurance to landlords that should any of these changes be made, that they would expect the tenant to return those back to the original settings when they first entered the property. I think it's quite interesting that the bill has little to say on social tenants making changes to let properties, but when you contrast that with the private sector in the bill, it does make it does make you think that social tenants have perhaps been overlooked in this case. I think there's slight differences between the new private provisions and the existing social provisions, but I think we've got to make sure that should tenants be allowed to make changes, and I don't think necessarily anyone's arguing against that, but it's also making sure again that there's a degree of reasonableness and also in proportion in terms of what would be expected, and obviously the cost that a landlord would have to incur in order to make changes back once the tenancy has ended. 174 relates to making it a duty for Scottish ministers to specify changes to let a property that has been made by the tenant. I think that's really important. We're talking about category 1 and category 2. I've already referenced in what the current definitions of those are. But again, you know, I think it's got to be made clear in guidance that should changes be allowed, that landlords know exactly what those changes look like and what scope those changes may fall under. If not, I think you might have a lot of discrepancies in terms of what a landlord may think is reasonable and what a tenant may think is reasonable. And I don't think that would be helpful to have those particular disagreements occur because it hasn't been properly legislated for in this bill. 175 relates to structural changes to a property, must not be categorised as category 1. Again, I do believe that this is on the back of conversations that Edward Mountain has had within the private rented sector themselves. I do believe that the government should clarify category 1, category 2 changes, just as I've referenced. And again, this is one of the amendments that would seek to provide more clarity by not including those structural changes as category 1. In relation to 177, again, it's to make it a duty for the Scottish ministers to make provision about when it is reasonable to refuse consent for a category 2 change. Of course, that's going a step above category 1. And again, I think that's again fair, measured, reasonable in terms of what tenants might seek to do to a property. It wouldn't be the standard, you know, painting walls of a certain colour, but I think again the clarity on top of provisions to refuse consent would be helpful in that respect. 178. Scottish ministers must by regulations make provision about when it is reasonable for a landlord to refuse to consent to the making of a category 2 change to let a property. Again, this is similar to the previous amendment 177, and in terms of 179, the amendment deems that the landlord may reasonably refuse any structural changes to the property. And again, I think it's to make sure that when we're talking about these particular changes that we have a seamless direction in terms of what's expected, what's allowed, and you know what guidance landlords can reasonably follow. That I don't believe the bill in its current form necessarily picks up at this moment in time. There's only other 2 amendments within this particular section, convener. So I think it's more appropriate to allow the speaker of those amendments to come in firstly with their view, and I can certainly summarise at the end. Thank you.
That Maggie Chapman, Megan Gallagher to move amendment 173.
Moved, convener.
Thank you. And Maggie Chapman to speak to amendment 262 and other amendments in the group.
Thanks, convener. My amendment 262 continues on from my amendments on assistance animals in the last group. It takes the Equality Act provisions on changes to rental properties for disabled people as a starting point, but makes more explicit that changes to make the property accessible should not require explicit approval. It is meant to clarify disabled people's rights in relation to changes to property and to stop disabled people having to rely on the vague provision of Section 190 of the Equality Act. These include changes to make it wheelchair accessible, accessible washing and cooking facilities, facilities related to assistance animals, and the installation of guard and handrails and visual alarms and bells. As with my previous amendments, these are supported by the Health and Social Care Alliance, Guide Dogs and Sight Scotland. I'm happy to work with colleagues on the drafting of the amendments ahead of stage 3 to address my concerns they might have about any particular wording of that amendment. My Amendment 252 establishes a right to grow in outdoor spaces of rented properties. The physical and mental health benefits of gardening and growing your own food are well established, and this amendment ensures that there should be no undue barriers to renters using outdoor spaces that are part of the property to grow their own, as well as to promote animal and insect life, such as by planting flowers which support pollinators. This kind of action is vital as we are facing a nature emergency, with many of Scotland's animal, insect and plant species threatened with extinction. And with young people in the most deprived areas of Scotland having significantly worse access to play space, the amendment also seeks to make it easier for modest changes to be made to garden and other spaces so that they can enjoy the benefits of outdoor play. Turning to other amendments in this group, major structural changes should be out of scope. So Green support Edward Mountain's 176 and 179. But on his Amendment 173, I think while it would help smooth the process of tenants gaining approval to make changes to a property, however, requiring all changes to be reversed unless the landlord agrees otherwise might have unintended consequences, such as for disabled people who have made accessibility changes. So I would ask Edward Mountain to work with colleagues ahead of stage 3 to address these concerns. Thank you, Convener.
Thank you. Do any other members wish to speak? Cabinet Secretary.
Turning to Amendments 173 to 179 by Edward Mountain in relation to making changes to let property. Amendment 173 places a statutory duty on a tenant who has made a Category 1 change or a Category 2 change to a let property, unless the landlord agreed otherwise, to ensure that the let property is returned to its original state at the end of the tenancy. This may discourage some tenants from making use of their right to make changes to the let property. Even perceived improvements may have to be stripped back if the landlord did not agree that they could remain, with no test on the reasonableness or the proportionality of this. Measures in the bill enable Scottish ministers, following consultation, to set out through regulation a non-exhaustive list of reasonable conditions a landlord may set where they consent to a Category 2 change, such as reinstatement at the end of a tenancy, where it was reasonable in the circumstances to do so. Where a tenant did not view this as a reasonable condition, they would have route of redress through the tribunal. Turning now to Amendments 174 to 179, I recognise Mr Mountain is seeking to provide some greater clarity and certainty on the face of the bill, as well as making sure ministers make use of the regulation-making powers. I can reassure members of the committee that while the current drafting of the provisions say may, making use of this regulating-making powers will be an essential part of the implementation. The framework relating to personalisation would require that detail be filled in via regulations already in order to set out the pertinent definitions. I understand that both landlords and tenants will, in particular, be keen to understand what will be able to be done without consent under Category 1, for example, putting up a picture, and what will fall under Category 2, for instance, painting walls, which will need consent. I am, however, clear that it is essential that the detail of the types of changes that fall into each category is best developed through consultation and engagement with the sector and set through secondary legislation. That's why the bill specifically includes statutory provisions that require consultation for the exercise of the regulation-making powers under the affirmative procedure. This will ensure we take account of both landlord and tenants' views. It will also ensure further public and parliamentary scrutiny of how these powers are used. Amendments 252, in the name of Maggie Chapman, seeks to set out some of the detail for Category 1 changes that would not require the permission of the landlord. The amendment is exceptionally broad in its scope and would allow for a very broad range of changes to the outside of a property without the landlord's involvement. While I recognise the member has included within this amendment that the change must be reasonable, however, as this would be Category 1 change, there would be no ability for the landlord to prevent the change if given prior knowledge, or recourse for the landlord where they did not view the change as reasonable after it was carried out. Legislation must strike the right balance when providing new rights to tenants with the rights of landlords. This amendment does not do that, and I therefore cannot support it. The detail of the changes to be included in Category 1 and 2 are best provided through the secondary legislation I have mentioned before and in development with landlords and tenants through consultation. Existing measures in the bill provide the framework for this, and this is the right way to facilitate those greater rights for tenants while respecting landlords' rights. Amendment 262, also in the name of Maggie Chapman, sets out a broad range of changes that a disabled tenant or a tenant who is a guardian or carer of a disabled member of the household could make without needing permission. I'm very sympathetic to the outcome Ms Chapman is seeking to achieve here, and I too wish to see the lives of disabled tenants, guardians and carers made easier. However, as with the previous amendment, this would allow for a broad range of potentially very significant changes to a let property without any involvement of the landlord. Setting this out on the face of the bill, without consultation or engagement with both tenants and landlords on the provisions, does not enable us to ensure we have the right balance between their respective rights. Existing measures in the bill provide the overarching framework needed for us getting this right. As I have already indicated, this requires further consultation to inform what types of changes would fall into Category 1 and Category 2. Regulations are also subject to the affirmative procedure, ensuring additional scrutiny from Parliament, and this is the best way to deliver the rights in this area while ensuring they are compatible with landlords' rights. I would therefore ask Edward Mountain and Maggie Chapman not to press the amendments in this group. Thank you, Convener.
Thank you. Megan Gallagher to wind up. Press or withdraw Amendment 173.
Thank you, Convener. I do believe that it is Edward Mountain's intention to press these amendments, but welcomes the conversation that we've had just there in terms of what's best in terms of providing clarity, guidance, regulations, secondary legislation. But I do believe that all of these in the round, need to be brought forward as quickly as possible in order to make sure that the private rented sector are aware of the changes that could potentially happen to the properties that they let out, but also for tenants as well who wish to make adaptations to their homes. I'm also sympathetic to Maggie Chapman's amendment of 262 and would welcome a conversation with her in the approach to stage 3 in terms of how we can look at the amendment, because I do believe that she raises a really valid and important point in terms of whether a tenant has a disability, and in terms of measuring that and what adaptations they therefore can make to their home to make their lives easier as well. But I think as we're looking to housing of the future, we're seeing this a lot now with new build housing in particular, that these adaptations are usually made as commonplace within these housing situations anyways, whether you're talking about rails or whether you're talking about wider doors, all of these things. But again, it's looking at it in a reasonable and pragmatic way, and I think we could have those conversations in the run-up to stage 3 to see how that would look, how that would impact the private rented sector, but also make lives more comfortable for tenants who have a disability in these particular types of housing. In relation to what we've said in terms of Category 1 and Category 2, I do believe that we need more clarity in terms of what we've got at present. It says the engagement questionnaire suggested that Category 1 would be the putting up of pictures, posters on walls, as I've said, but elsewhere in that document it suggested that Category 2 would look like painting walls and installing wall shelves. But again, that's very, I would say, limited in terms of what other adaptations could be made. I understand that that's going to come following further consultation and engagement. But again, I think this has been the reason why members have submitted amendments of this nature, is because that they're unsure how that's going to look. They've obviously had discussions with the sector in itself and therefore wanted to bring that clarity onto the face of the bill. With that, Convener, I would seek to press and move Amendment 173 in the name of Edward Mountain. Thank you.
Thank you. The question is that Amendment 173 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. All those in favour of Amendment 173? All those against? Abstentions? Thank you. The result of the division on Amendment 173 is 3 for, 3 against and 1 abstention. As there is a tie, I must exercise a casting vote, and my vote is against the amendment, so the amendment has been disagreed. I call Amendment 174 in the name of Edward Mountain, already debated with Amendment 173. Megan Gallagher, to move or not move?
Moves, Convener.
The question is that Amendment 174 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. All those in favour of Amendment 174? All those against? The result of the division on Amendment 174 is 4 for, 3 against. The amendment has been agreed. I call Amendment 175 in the name of Edward Mountain, already debated with Amendment 173. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 175 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 175? All those against? The result of the division on Amendment 175 is 4 for, 3 against. The amendment has been agreed. I call Amendment 176 in the name of Edward Mountain, already debated with Amendment 173. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 176 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. All those in favour of Amendment 176? All those against? The result of the division on Amendment 176 is 4 for, 3 against. The amendment has been agreed. I call Amendment 262 in the name of Maggie Chapman, already debated with Amendment 173. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 262 be agreed. Are we all agreed? No. We're not agreed. There will be a division. All those in favour of Amendment 262? All those against? The result of the division on Amendment 262 is 2 for, 5 against. The amendment has been disagreed. I call Amendment 252 in the name of Maggie Chapman, already debated with Amendment 173. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 252 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. All those in favour of Amendment 252? All those against? The result of the division on Amendment 252 is 1 for, 6 against. The amendment has been disagreed. I call Amendment 177 in the name of Edward Mountain, already debated with Amendment 173. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 177 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. Those in favour of Amendment 177? Those against? Fulton, when we're voting, can you put your hand more closely to your face when to indicate your choice in subsequent votes, please? So, The result of the division on Amendment 177 is 4 for, 3 against. The amendment has been agreed. I call Amendment 178 in the name of Edward Mountain, already debated with Amendment 173. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 178 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. Those in favour of Amendment 178? Those against? That's very clear. The result of the division on Amendment 178 is 4 for, 3 against. The amendment has been agreed. I call Amendment 179 in the name of Edward Mountain, already debated with Amendment 173. Edward Mountain, to move or not move?
On behalf of Edward Mountain.
Thank you, Megan Gallagher. Are you moving it? Super, thank you. The question is that Amendment 179 be agreed. Are we all agreed?
No.
We're not agreed. There will be a division. Those in favour of Amendment 179? Those against? It's because of the background, isn't it? Yeah. The result of the division on Amendment 179 is 4 for, 3 against. The amendment has been agreed. The question is that Section 29 be agreed. Are we all agreed?
Yes.
Okay, we're going to now move on to the next grouping, which is social housing, Scottish secure tenancies. And I call Amendment 440 in the name of Paul Sweeney, grouped with Amendments 456, 423, 457 and 457A. Paul Sweeney, who is joining us on the line, to move Amendment 440 and to speak to all amendments in the group.
Thank you, Convener. I beg to move that my proposed Amendment 440 be agreed to by the committee. The purpose of the amendment is to bring the legislation in terms of housing into line with sections 109 to 113 of the Cooperative and Community Benefit Societies Act of 2014. This would mean that registered social landlords can only transfer engagements if 2/3 of tenants vote in favour of the resolution to do so. It currently requires just a simple majority of tenants to proceed through the process. Section 111 of the Cooperative and Community Benefit Societies Act of 2014, which governs shareholders voting in takeovers of societies and is a UK-wide piece of legislation, stipulates that a special resolution is passed at a general meeting by at least 2/3 of the eligible members who vote. In this case, the reason why I've been motivated to bring forward this amendment is due to the case of Reedvale Housing Association, which happened in 2023-2024. Had this measure been in place, the tenant ballot would not have reached the threshold required to proceed to the special general meeting, which then did not meet the 2/3 majority requirement. In December 2023, Reedvale Housing Association proposed to transfer its housing stock of 900 properties valued at around £180 million to Places for People Scotland, and a tenant ballot that was open for 32 days, with 72.9% of tenants casting their vote, found 61.8% of tenants voting in favour of the proposal. Had this 2/3 majority rule been in place, the proposal would have fell at that point because it hadn't met the threshold of 66.6%. As you may know, the Reedvale Housing Association was one of Scotland's first community-based housing associations, formed after the 1974 Housing Act. In 1975, it has around 900 homes in the Denniston area of Glasgow. There have been significant concerns about its governance and investment, and the board had decided to seek a transfer partner to take over the association, its tenancies, properties and staff. However, this had elicited significant concern about the process being railroaded through with significant coercion, and the Glasgow and West of Scotland Forum of Housing Associations had resisted the proposal. They highlighted concerns about the tenant ballot itself. Their director, David Bookbinder, the Glasgow West of Scotland Housing Association Forum director, said at the time that the 61.8% yes result in favour of transferring the housing stock must be viewed in the context of previous transfer votes, most of which have generated positive results by at least 90%. And indeed, if you look at the scope of recent transfers of engagements of housing associations over the last few years, they've all largely been over 90% supported. I think only one fell below the 90% threshold, which was Pineview and Kendoon, the transfer, which was at 88% support. So clearly, in instances where transfers of engagements are sought, they should enjoy the vast majority of support of the tenants for it to be a reasonable proposition. And with yes votes in transfer ballots normally exceeding that 90% threshold, it was clear that in the case of Reidvale, there was a concern that almost 40% of voting tenants had opposed the transfer, despite the offer of a 5-year rent freeze. It's hardly a resounding vote of confidence in that case. And I think that's why this measure of a supermajority of 2/3 support makes it clear that there is a settled majority view within the tenant body that this is the best future for a community-based housing association. After all, it's a one-way road from being a community-based association into a large national housing group. There's never been a case in Scotland where a large national housing group has devolved or spun out a small community-based association. So I think it's important that we do this to protect the sector. What happened in the case of Reidvale was that with the required approval of the transfer by Reidvale tenants in place by a simple majority, Reidvale then went forward to a special meeting of its shareholders in January 2024 to seek ratification of the transfer of engagements to Places for People. But what happened in January 2024 at the special general meeting held on the 16th of January was that 138 shareholders, or 66.3%, voted to reject the takeover and back continued community ownership, with only 70 shareholders, or 33.6%, supporting the transfer. And it was clear at that time that there was a huge victory for community-based ownership, and it was based on a grassroots campaign which was fighting against an overwhelming narrative that transfer to a large national housing group was the only there was no alternative to it, and to present a counter proposal was very challenging, but nonetheless it cut through and was able to win the support of the shareholders. The Glasgow and West of Scotland Housing Association Forum Chair John Hamilton said at the time that as an obvious supporter and promoter of community-based housing associations, the GWSF welcomes the 2-1 decision of Reidvale's members not to ratify the outcome of the tenant ballot, and we recognise many of the concerns expressed by members, including the impending loss of community assets and the inevitable disappearance of local decision-making, the relative closeness of the separate tenant ballot with less than 62% in favour compared with the usual 90+% yes vote in previous transfers was a clear sign of the anxiety and uncertainty felt by many tenants despite the promise of a 5-year rent freeze. That's why I think this amendment is reasonable, coherent and a prudent measure to bring the voting thresholds for tenants and shareholders of housing associations into alignment with a 2/3 threshold, and that will serve to give some extra protection for community control of housing associations from what are often cynical attempts to railroad through irreversible takeovers of community-controlled assets, and the risk of pitting tenants against member shareholders, which has been a worrying trend in Scotland's housing scene in the last few years. I think it would also be particularly fitting if the committee would support this amendment, because this year marks the 50th anniversary of Scotland's first community-based housing associations being established, and the proposal has the backing of the Glasgow and West of Scotland Forum of Housing Associations. Thank you very much. I beg to move.
Thank you, Paul. And I now call Mark Griffin to speak to Amendment 456 and other amendments in the group.
Thank you, Convener. Amendments 456 and 423 work together to make a slight practical change to how RSLs are required to give notice of rent increases to tenants. If passed, these amendments would allow notice to be delivered by normal post as well as by hand, email or tracked mail. Currently, associations are obligated to use tracked mail, email or hand delivery in order to meet the existing legal requirements under the Housing Scotland Act 2001. Housing associations agree that hand delivery of the notices is unnecessarily resource intensive and wasteful, that email delivery does not offer a guarantee that all tenants would receive the notice, and that tracked mail is too expensive an option. In Scotland, existing legislation sets out that documents can only be given by personal delivery to the person by a method of post that can be recorded or by agreed electronic transmission. However, the general law can be overruled by the specific terms of a statute, so I'm confident that this amendment is legally competent. The amendment will allow landlords to deliver notices by different delivery methods, specifically stating that standard post can be used without any legal implications, and lessening the burden of compliance with housing legislation or RSLs, leaving them with more time to support tenants in other ways and deliver a strong supply of housing in Scotland. On amendments 457 and 457A, these amendments ensure social landlords can't prevent families from moving to more suitable accommodation because they have outstanding house arrears and housing-related debts, where the current accommodation does not meet families' needs, without also preventing debt recovery action. In many cases, people in low incomes and in unsuitable accommodations can be trapped in a cycle of debt. If they're in social housing, the opportunity to move to more suitable accommodation can be denied by the organisation if they have built up arrears. This can leave families trapped in debt and in housing that's either too big, not safe or overcrowded. Unaffordable, overcrowded and substandard housing conditions have an adverse impact on people's ability to cope both physically and mentally, and on wider family well-being. And this can be then cause the cycle of debt to be exacerbated. Urgent and compassionate reforms to public debt management and recovery, including rent and housing arrears, are required to tackle child poverty, support families, uphold children's rights and ensure every child and family has the opportunity to thrive. We need to promote compassionate and supportive debt management approaches. It's imperative that public bodies and housing associations develop debt recovery policies that recognise the impact of domestic and economic abuse to prevent victim survivors from being pursued for coerced debt in their name as a result of abuse. My amendments work to prevent families from being denied more suitable accommodation for them as a result of built-up arrears. This will create greater protections for families affected by domestic abuse and ensure greater consistency with statutory human rights and children's rights duties, and equally safe commitments for protecting women and children from the impact of violence and abuse. Accept that local authorities should be able to pursue arrears, but don't believe that this is best done by preventing families from accessing more suitable accommodation when it becomes available. Thank you.
Okay, thank you very much. Do any other members wish to speak? Cabinet Secretary.
Thank you, Convener. Can I welcome the conversations that I've had with Paul Swinney, particularly with regards to community-based housing cooperatives. I myself spent many an enjoyable time in my placements as I was training to be a housing officer at community-based housing co-ops, so I absolutely share his passion for them and for their place in our housing sector. So I thank him for his interest in this area. I unfortunately cannot, however, agree to the amendment that he's brought forward in this group. While I understand his intentions seeking to ensure that the views of tenants are rightly taken into account in such significant decisions related to their homes, I do have reservations. The current position set out in Section 107 of the Housing Scotland Act is that for a transfer to proceed, a majority of tenants to agree to it. The rationale for suggested change is not wholly clear, although I appreciate the comments that Mr Sweeney has made about Reedvale Housing Association. But moving to a requirement for 2/3 of tenants may be viewed as setting out a position where the express wish of a majority of the tenants can therefore be ignored. Given that there has not been consultation with the sector, either landlords or tenants, it is difficult for the Government to support such a change to what has been in place since 2012. I understand that 21 transfers out of 22 proposed since 2010 have all received well over 2/3 tenant approval. Whilst this could suggest that this amendment would not be problematic in practice, it could indicate that there is no real need for change as well. For those reasons, I would urge Mr Sweeney not to press. Turning to amendments 456 and 423 by Mark Griffin, which aim to amend the provisions in the Bill for social landlords to serve rent increase notices to allow these notices to be sent by regular post. A social landlord is required to provide a tenant with 28 days' notice of a rent increase, and the 28-day period needs to be evidenced. If a notice does not reach the intended recipient, then they could be unaware of the rent increase, which could result in a tenant being in rent arrears. Tenants would not be able to evidence any change that they had not received the rent increase notice if regular post is an acceptable service method. Consequently, there needs to be certainty that the notice has been delivered to the tenant, which a tracked service provides but regular post does not. The bill at present, which also allows for electronic or personal service, aligns the service options for the social rented sector with the private rented sector. This amendment removing the requirement for a tracked service would be at odds with the protection provided to tenants in the private rented sector. The bill already provides for 2 additional methods of delivery to the existing methods. One is for electronic delivery, reflecting increased use of web-based tenancy management systems, email and paperless communications, which over time is likely to become the default for the majority of tenants and will primarily be cost neutral for landlords. The other is for a tracked postal service to point of delivery, which removes the requirement for a signature. I would therefore urge Mark Griffin not to press. Turning to amendments 457 and 457A, whilst I understand the intention behind Mark Griffin's amendments, they would prevent a landlord refusing consent for a mutual exchange on the basis of rent arrears where the criteria set out in his amendments are satisfied. These are that one or more children under 18 live with the tenant and their current home is inadequate and the proposed exchange home would be suitable. This would apply regardless of the total amount of rent arrears or whether the tenant was currently paying the rent arrears or keeping to a repayment plan. The only situations where the landlord could refuse consent for a mutual exchange would be where a notice of proceedings had already been served on the tenant on conduct grounds or an eviction order has been granted against the tenant for the current tenancy. Whilst Mr Griffin's amendments wouldn't prevent the landlord from taking steps to recover any rent arrears, these would become former tenant arrears. These are generally more difficult for social landlords to recover and often have to be written off, reducing landlord income, impacting on the service social landlords provide to tenants and being able to maintain rent levels that are affordable. Social landlords already have discretion to agree to a mutual exchange between their properties where there are rent arrears if moving to a property with a lower rent would be more financially sustainable for the tenant and for a repayment plan in place. I do accept the points that Mr Griffin made in his remarks around those suffering from domestic violence and where there is domestic abuse on the home. I would be happy to have conversations with Mr Griffin in the run-up to stage 3, and particularly those aspects around where there is either a threat or has been a history of domestic violence. But on this occasion, at this point, I would urge him not to press.
Okay, thank you. Paul Sweeney to wind up, press or withdraw Amendment 440.
Thank you, Convener. I'm disappointed that the Cabinet Secretary doesn't see the logic in having this amendment. I think the fact that the Wheatvale case was so unique demonstrates the need for an extra safeguard of having a settled majority of tenants. Actually, what happened in the case of Wheatvale was a significant level of discord in the community about contentious transfer, and I think the way to deal with that is to have that settled majority. And as the Cabinet Secretary highlighted, in every other example of a transfer of engagements in Scotland, that tends to be the case, that there is a supermajority in support of transfer of engagements. So I think it is a measure that I would like to see on the face of the bill. I think it's a good safeguard, and it's a demonstration that we've learned the lessons of what happened at Reidvale in one of Scotland's most deprived communities. The loss of over £100 million worth of community-owned assets would have been devastating. So I would like to try and work to build support for this amendment. Therefore, I won't press it just now, but I will look to return at stage 3, and perhaps we can have a discussion. Given that there is an agreement and the sentiment behind the amendment, perhaps there is a way to find an appropriate wording or measure that we can put in place to provide that extra threshold that brings it into alignment with what's required for shareholders anyway. The reality is that you need a 2/3 majority of shareholders, so why not just increase the thresholds for tenants as well? And that brings everything into alignment. It's a very neat, logical process.
Paul Sweeney to press or withdraw Amendment 440.
I'll withdraw Amendment 440 at this stage.
Thank you. Paul Sweeney seeks to withdraw Amendment 440. Does any member object to the amendment being withdrawn? There are no objections, so the amendment is withdrawn. I call Amendment 263 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 263 be agreed. Are we all agreed? No. We are not agreed. There will be a division. All those in favour of Amendment 263? Okay, hang on a moment. We need to get put on the screen. Okay, I'll run that again. All those in favour of Amendment 263? Those against? Abstentions? The result of the division on Amendment 263 is 2 for, 4 against, and 1 abstention. The amendment has been disagreed. I call Amendment 264 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 265 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 180 in the name of Edward Mountain, already debated with Amendment 522. Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 180 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. All those in favour of Amendment 180? Those against?
Edward's doing incredibly well.
The result of the division on Amendment 180 is 4 for, 3 against. The amendment has been agreed. I call Amendment 181 in the name of Edward Mountain, already debated with Amendment 522. Edward Mountain, to move, Megan Gallagher, to move or not move?
Moved.
The question is that Amendment 181 be agreed. Are we all agreed?
Yes.
We're not agreed. There will be a division. Those in favour of Amendment 181? Those against? The result of the division on Amendment 181 is 4 for, 3 against. The amendment has been agreed. I call Amendment 182 in the name of Edward Mountain, already debated with Amendment 522. Megan Gallagher, to move or not move?
Moved, convener.
The question is that Amendment 182 be agreed. Are we all agreed?
No.
We are not agreed. There will be a division. All those in favour of Amendment 182? Those against? The result of the division on Amendment 182 is 3 for, 4 against. The amendment has been disagreed. Call Amendment 27 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 27 be agreed. Are we all agreed?
No.
We are not agreed. There will be a division. All those in favour of Amendment 27? Those against? The result of the division on Amendment 27 is 2 for, 5 against. The amendment has been disagreed. I call Amendment 530 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 531 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 532 in the name of Emma Roddick, already debated with Amendment 522. I remind members that Amendments 532 and 28 are direct alternatives. That is, that they can both be moved and decided on. The text of whichever is the last agreed to is what will appear in the bill. Emma Roddick, to move or not move?
Not moved.
I call Amendment 28 in the name of Maggie Chapman, already debated with Amendment 522. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 533 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
I call Amendment 534 in the name of Emma Roddick, already debated with Amendment 522. Emma Roddick, to move or not move?
Not moved.
The question is that Section 30 be agreed. Are we all agreed?
Yes.
We are all agreed. At that point, we've come to a convenient point in our groupings, and I'm going to close our work on the housing bill for now. We're going to pause this agenda item and we'll return to it later. As previously agreed, we will now move into private to consider agenda item 5, which is our annual report. And we will continue day 5 of our consideration of the Housing Scotland bill at stage 2 this afternoon at 2:20 And for now, I thank you, and as I said, we'll now move into private.